Yes. Next week. Okay. 2000 next week. Next week.
Serial number 64, ma'am.
What is it? What is the matter? Huh? Next week. Next week. After 2 weeks. After 2 weeks. After 2 weeks. Next week and the Arthagala. In urgency, anything. Because you want to go abroad, we have to all run the helter skelter. When were you expelled? What were you doing? Sleeping for 1 year? Then? Today you come and you want it tomorrow. All right. Next week we'll have it. You argue. If you make out a case, take the relief. Okay? All right. What matter? Unable to understand what you're saying. Speak on the mic. Speak on the mic. Mic mail madri. Ridiculous. Years of increment. But next week. Next week. Okay, no. Posting of case LU. GM CPC Namagilla. Not heard. I have heard that. Yes. What is second? Hmm? You are able to understand what he said. Mike ಕೊಟ್ಟಿದ್ದಲ್ಲ ಅದು ಹಿಂದಿ ಇಟ್ಕೊಂಡ್ರೆ ಇದ್ರೆ ಮೈಕ್ ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಮುಂದೆ. Why do you put it behind your ears? Don't act like an uneducated, sir. You're a lawyer. Mic is provided for you to put it in front of your mouth, not behind your ears. Next week. I don't understand the lawyers why you put your mic behind your ears. Taken on? Taken on when? When is the exam? Madam, when is the exam is not allowed. When is the exam? When is the next exam you want to take? So now. So the result is withheld. If you pass, you have to take the next exam for the next semester. When is that? There will be some date for the examination. Even if you have finished the course, you have to take semester exam. Madam, even if that course is over, when you want to take, what is the relief you are asking? What relief you want? That's all. Only declaration of result. So once the results are declared, your relief is that all. Post it next week. Give it. We'll have it next week. You are a purchaser. When is the order passed? What is the order? Already. Posted on 3rd.
Amendments page wise.
What proceedings? What proceeding? Surfacing. Oh.
2019 matter of and meanwhile, immediately
Speak. ಯಾವುದು ನೆನ್ನೆ ಆರ್ಡರ್ ಮಾಡಿ yesterday that is must have already I must have signed it. You want the operative portion of it already. Just tell them now only to keep it ready so they can do it.
Page number 11, number 43 to 48.
My lordship, I'm 48 serial number. I'm for the respondent counsel. I need 1 week adjournment. I've informed the petitioner counsel also, my lordship. Serial number 48.
Request of counsel for petitioner released next week.
Serial number 47, my lords.
Yes.
Appearing for the petitioners in this case, my lord, senior is having some personal inconvenience and may be taken up in the next week, please, my lords.
At request of petitioner released next week.
Grateful, my lords.
Page number 12, number 49 to 16.
I'm appearing for respondent, your lordship. Serial number 49.
Don't share Amma. In big. You are for petitioner. Petition. At request of learned counsel for the petitioner released next week.
Serial number 49, your lordship.
Yes, what do you want, madam?
Adjournment for 10 days. I have filed my wakalat. I need to file my objections to the petition.
On request of learned counsel for the petitioner.
I'm
Released next
respondent.
week. Respondent. Released
Yes.
next week. Now, what objections you want to file? What you argue? What is there to file objections? At request of learned counsel for the respondent released next week. Why? Madam, 2013, I am not going to grant time, even if your senior is there or not. You get ready and argue. Otherwise, I will hear the respondent and pass orders. Please go through the file. You want, you can take the court file and read it. 50. What do you want? At request of learned counsel for the respondent, released next week. Next week.
Page number 13, number 61 and 62.
64, my lord.
61 and 62.
May not be on Friday, the bench matters will be there. Have it on Monday. At request of learned counsel for the petitioner, release this matter on 6th.
Serial number 64, my.
Number 63 to 67.
64, my lord.
Yes.
Appear for appellant. I have informed the other side also. I am not feeling well. Hence, I pray 1 week time, my lord.
Learned counsel for the appellant submits that he is not keeping good health and seeks a week's accommodation. He also submits that he is informed the counsel for respondent and to release this matter next week.
Much obliged.
Page number 16, number 68 to 72.
Right? The petitioner. At request of learned counsel for the petitioner, matters adjourned by 3 weeks. We have the fact that learned counsel has undergone certain medical operations. Certain list after 3 weeks.
Page number
Inform the other side.
17, till number 73 to 77.
Request of learned counsel for the petitioner released next week. Interim order if any is. What? Is restored.
Is there and the practice?
She's seeking 1 week. You're going to argue? Why you're not ready? We'll have it on Monday. Let her argue. Get ready on Monday. At request, whether interim order is there. Interim order, if any, extended till next week. Release this matter on Monday, 6. Then Beko? Yen restoration copy. That I allow it. You want that I? It was without hearing you, it was passed. Huh? But anyway, that is allowed. You want to challenge that, you can challenge that. You have a copy of the petition.
Page number 18, till number 78 to 83.
No serial number. 82 and 83. At request of learned counsel for the petitioner by 82 and release next week or 2 weeks.
Page number 19, till number 84. Till number 1.
There's no representation. Relist next week.
Number 2.
Third learned counsel for the petitioner. Issue notice to respondent. Counsel for the petitioner is permitted to take out notice on the counsel representing respondent before the family court at Chikmagalur or at Bengaluru. What do you want? Notice ಆಯ್ತಲ್ಲ ಇನ್ನೇನ್ ಬೇಕು ಸಾಕ ಸೊ ಡೋಂಟ್ ವಾಂಟ್ ಹಿಮ್ ನಾವು ಹುಡುಕ್ತಾ ಇದ್ದೀನಿ ಐಯೇನೇ ಇಲ್ಲ ನಿಮಗೆ ಮುಂಚೆ ಹೇಳ್ಬೇಕಲ್ಲ. Nagamangala. Just the distance. What's the distance? So you're a resident of Nagamangala? Matrimonial, heard. Don't counsel. Madam, you're writing down, both of you. You know the format which I also. Heard issue notice on suspension. There shall be orders on IA, stay, all for the proceedings in MC number 879 of 2017 on the file of 6th Additional Principal Judge, Family Court, Bengaluru, till next date.
I appear for the petition. I appear for the petition in serial number 4, my lord.
Yes. Yes.
This is the wife's petition for transfer, madam.
Hmm.
The wife is staying at Bangalore. In fact, husband and wife both were staying in Bangalore at one point of time. When they got married, both were software engineers working here. Then, since the respondent husband, parents were in Tumkur, he filed the petition from Tumkur for divorce. There is another petition filed by the petitioner under the Domestic Violence Act at Bangalore. And she is having a 2-year-old girl child, infant baby, plus aged parents to look after at Bangalore, madam.
So the custody of the child is with you?
No, yes, with me only.
Same order. There shall be stay of all further proceedings in MC 198 of 22. Pending on the file of First Additional Principal Judge, Family Court, from court till next date.
Much obliged.
Court notice on the council.
Yes, madam. Much obliged.
Yeah.
You want transfer from Sindhanur to Manvi? Bangalore. Of that council. Same order. She notice also. Orders on IV1 that will be clear for the proceedings in MC number 42 of 2022. Pending on the file of Senior Civil Judge JMFC Sindhanur sitting at Manvi. Next date of hearing.
Number 6, Jagdish Mukherjee.
Appear for the petitioner, my lord. The vice petition, my lord, I am seeking transfer from Tarikere court to Davangere. In Davangere, already there are 2 cases been transferred. One MC case filed by the respondent husband. Earlier, he filed a restitution of conjugal rights in Tarikere that was got transferred to Davangere family court. Then he withdrew and filed the divorce petition now before the Davangere family court. And he filed a criminal case also in Tarikere. And that also by this honorable court was transferred to Davangere. She lost her father and mother. She lost my mother recently. There is a child, 7 years old. She is in custody of the child.
So the matter to be transferred is a custody petition.
Yes, my lord. GNWC.
What happened to that MC case?
My lord, he filed first restitution and we got it transferred from Tariket to Davangere. Then he withdrew that petition and now he has filed a divorce petition before the family court at Davangere, which is pending.
Heard, learned counsel for the petitioner. Issue notice also. Orders on A1, shall be stay of all further proceedings in GNWC number 21 of 22, pending on the file of Senior Civil Judge JMFC Tarikere, Chikmagaluru, till next date of hearing.
Much obliged.
Hmm. What is the distance between Sakleshpur and Chikmalapur? Heard. Orders on A1, there shall be stay of further proceedings in MC 44 of 22, pending on the file of Senior Civil Judge JMFC Sakleshpur, Hassan District, till next date of hearing. Have you filed any petition in Mysore? Heard. Issue notice. There shall be stay of further proceedings in MC 59 of 23, pending on the file of 6th Additional Principal Judge Family Court, Bangalore, next date of hearing. What's the distance? What is filed by the respondent at Davangere? Heard, learned counsel for the petitioner. Issue notice shall be stay of all further proceedings in MC number 150 of 20, pending on the file of which court? And then Iradal. Only one family court. Family court at Davangere. Till next date. Matter is the sleeping. Why don't you go and join your husband? Yes. You don't want your husband. Don't want to join your husband.
He's ready, but at present he is unable because he is doctor school. Nomination. Then she is unable to also, plus is listening at Consul. He is listening down there.
Mysore ಕೆಲಸ ಸಿಕ್ಕಲ್ವಾ ನಿಮ್ಗೆ? Okay. Huh? So the priority of your husband is your job. The priority between husband and the job is more priority for you.
Very husband himself is very trying to daughter also.
Huh? Yaro? Right, you shift, sir. You don't understand the relationship. After some time, when you become old, you will understand the value of relationship. Now you're running around for job. Once you are done with your job and money satisfaction, then you realize the importance of relationship. When you go back home and you sit against the wall, when you talk to the wall, I don't understand this kind of attitude of your client. 34 years old, your client is. She's a doctor. In doctor. As it is, there is so much of stress for the doctors. When you go back home, don't you need somebody to talk to? Even if you don't talk, if some person is there. So you want to take care of your parents and not live with your husband. What example you are setting for your daughter? You will never get married. You have to advise as a counsel. That's the job of a counsel. Apart from collecting legal fee, which is legible, however. Advise your clients, sir. That's a noble profession. You have to advise. Sometimes it will not work for these people who are very much educated. They'll be flying high because of the income and job. So no use after some time. Third learned counsel for the petitioner. Emergent notice. Yeah, he's filed for conjugal rights. Have you filed for divorce? You want to separate from him? Issue notice. Issue notice. For what stay? Have you appeared before the court, Mysore? Have you filed wakalat there or is not? No. Have you filed wakalat in Mysore or not filed? Why? Won't appear there for mediation. Huh? Correct. For conciliation, mediation of bunny. Go for mediation. Even if your client cannot travel, let her appear through video conference, let the counsel be there. Explore, sir, possibly. Relist after 2 weeks. Let mediation happen. Oh no, this sympathy wave for which is given to these women are affecting the entire system. You lose your we lose our culture of Indianness. Indian culture will go. You will become Westerners. Drop off the hat, go and file divorce, live in marriage, live with somebody, child is not taken care. That's why you go first there, whether if is agreeable, both of them. If it don't happen, come back here. We will arrange for mediation for you. Advice Madi.
Your Lordship, serial number 11.
Yes.
For the petitioner, Your Lordship. We have filed the present petition seeking a transfer of the MC 40/22, which is filed by the respondent before the Senior Civil Judge JMFC Hosnagara Shimoga to JMFC at Narsarajapura, Your Lordship. Presently, the petitioner has also filed a criminal miscellaneous, that is DV case, before Narsarajapura, Your Lordship. And also, prior to filing the MC case by the respondent, the petitioner has filed one MC case, that is 19/21, before Narsarajapura, wherein the respondent has appeared before that MC case and agreed for going back to the matrimonial thing. Subsequently, the petitioner went back to the matrimonial house with the respondent, and because of the temperamental issues, the respondent again sent back the petitioner to the family, to their father's place, and now they are residing separately. Now the respondent has filed the present petition before the Shimoga district, wherein the petitioner is getting difficult to travel, Your Lordship, because she is residing in the remote village, that is Enarpura Taluk, which is also 10 kilometers away from the transfer petition where we are seeking. That is from Narsimrajapura.
And counsel for the petitioner. Show notice to respondent. Orders on
Also
IE.
filed.
There shall be stay hold for the proceedings in MC 40 of 22, pending on the file of Senior Civil Judge JMFC Sanagara, Shimoga District, Union State.
Obliged, Your
Well,
How old is the child? Third time order. Stay of further proceedings in MC number 672024 of 22. Pending on 5th additional Municipal Family Court, Bengaluru, till next date.
take the case.
Hmm? Have you filed anything? You have not filed anything. So what's your difficulty in joining your husband? Any children born? Any child with your petitioner? So you are resident of? Mediation agilla. Have you appeared here? Wakalat filed. Then appear. Go for mediation. Third learned counsel issue notice to respondent. Counsel for petitioner is permitted to take out notice to the counsel for respondent before the Family Court of Bangalore. Any children? Children are there? Not there. Have you taken notice in the Shimoga court? Have you accepted notice? Attended. Mediation is over. Go for mediation. Third Learned Counsel, issue notice. Counsel for petitioners permitted to take out notice on the counsel for respondent before the family court at Shimoga. Go and make an effort, mediation. You have not filed any petition. It's only section 9 by your husband. All right, if he allows, gives you maintenance and takes care of you, what's the difficulty? What's the difficulty? He will give you maintenance. Suppose if he says, I'll give you maintenance. Sir, you want to separate from your husband or join your husband, or you want to keep him in limbo? Then go and participate in mediation. Next. Make an effort. Make an effort. If it doesn't happen, come back. Mysore to Carpet. What is filed by the husband? Huh? For divorce. Children are there. Heard. Learned Counsel, issue notice. Orders on IE. There shall be stay of all further proceedings. MC 98, pending on the file of second additional principal judge, family court, Mysore, till next date. Issue notice to respondent. Counsel for the petitioners permitted to take out notice on the counsel for respondent appearing before the civil judge JMFC Kanakapura Ramnagaram. All India quota students. Some order already passed by me in this. This is not that This is not that compulsory service. Which is that other matter? Call this matter along with WPs also after 2 weeks. Shivakumar. Yesterday's matter. What have I? Now why it is listed today? So the same, both are same. Okay. So now you want to sell the land. Yeah, Anbardri, yes, Sunday. Yeah, la, yeah. To say yes, sir. Yeah is a slang language you can use on the corridors. So you use this. All right. So notice. You are appearing for both. Learning like CGP takes notice for respondents. Adi yavag hogide? When is it adjourned to? So stay was granted in that case also. There shall be an ad interim order of stay of operation of the conditions imposed in impugned order dated 31/10/2014 in RD 182 LGB 2013 passed by the first respondent and annexure B or DC na state who has passed the order. Annexure B yaar madu by the respondent one till next date of hearing. Call this matter along with have it after 2 weeks, next week. Next week you submit whatever you want to submit.
Number 90, 30K.
Only respondent. The postal track sheet shows that the notice issued to respondent is returned as refused. Hence, the same is held to be sufficient and deemed as served. Registry to show the name of respondent in the cost list. With the ITA, interim order, if any, is extended till next date of hearing. Absolutely. It is stayed, so there's no, you need not extend it every time.
20,
Full stop. You have to pay a fresh process fee then. Reissue notice to respondent. The PF is paid within 2 weeks. 2 weeks, or you want 1 week? Within 1 week.
21, 1K.
Speaker. Who's R1? Must be the claimant. 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 Oh no, is he the owner or claimant? Reissue notice, court notice to respondent. Number 1. Learned counsel for the appellant to make good the address, if any, known to him with regard to respondent number 1. Hmm. Who are you? Respondent one, Yaru. Yaru. No, your owner, claimant, insurer. Who are you? You also don't have contact with your client. Who has filed the appeal? You know that. But also you don't know. Mahadevamma. Is an appeal preferred by the claimants? Ah. There is Jagdish, Joint Judicial Service. Court notice ಹೋಗಿದೆ no? Correct. Appellant 1 is served, A2 not served, not residing. 3 is dead. ಎಲ್ಲರೂ ತರಬೇಕಲ್ಲ. Even served in person, Mahadevamma. There must be some aged ladies. A2 not served, not residing. The Barkoli. The postal share of service of court notice to appellant number 1 is returned as having served. So also the name is mentioned in the cost list. A2 is not served as not residing in the given address. A3 is reported to be dead. The appellant, the legal representatives of A3 be brought on record. 2 weeks time granted. You are appearing for whom? Who's R1? Huh? R1 Ravi. First time you are appearing in MVC cases? He is the owner of offending vehicle. In file odalla ನೀವು ಕೂತ್ಕೊಂಡು ಏನು ಮಾಡ್ತೀರಾ ಇಲ್ಲಿ? What not mentioned? Go and see your appeal, the claim petition. Don't sit here like you are sitting in come for some jatra. You may not have contacts here, at least submit the facts. How many years you are practicing? At least ಓದಬಾರದು ನೀವು ಕೂತ್ಕೊಂಡು ಇಲ್ಲಿ. Claim petition ಓದಕ್ ಬರಲ್ಲ. Who's R1? Who's R1? Liability is fastened on whom? Liability is first. You have you deposited the amount? Execution petition ಹಾಕಿಲ್ಲ ಅವರು ಇಮೇಲೆ. Sir, all MVC matters are 2013, 11 and 12. Get ready to argue on the next date. I'm going to hear it even if the appellants don't come. Counsel for the petitioner submits needful has been done. Service of IA. All right. Yes. What is it now? What is it? Who are you? Who are? You are appearing for? Who's R3? for vacating. Who was filed IA? What directions? You are ready? Are you ready in the matter? No. We'll list this matter next week. ಅವ್ರಿಗೇನೋ ಗೊತ್ತಿಲ್ವಲ್ರಿ ಅವ್ರ ಸೀನಿಯರ್ ಬರ್ಬೇಕಲ್ಲ. Shall I pass orders? No, whether this metal sheets of 165 roof, cement sheets, metal poles, 104 hangers belong to you. Are you admitting? She's a, it's your case, it belongs to you, whether they have admitted. What is the interim order granted? That is restoration. So you're in possession some when? From when? Or have you filed objections to this? Where is it? Whose photo have you produced?
Members of the society.
You have purchased agricultural land.
This is why we have 60. How does
In what nature it was gifted? What was the nature of the property? Where is that interim order for it? Who was gifted the land to you? One who? So he is the purchaser from the grantees. All right, let them come. Release this matter. We'll fix a date. Give a date. Get your senior to argue that. 14th March. Or what? For what? No, you file for 1 minute. IA1 and 2 is for recalling the order. What is that order? 18. Must have got dismissed. 18th of September.
18 September 2009.
How many dates were given to the last one, we have retained the 430.
Same parties or different parties? Who are you? Who are you? Yaruma, petitioner yar. You are grantee. So there's an order in your favor by the revenue authority, both the courts. What is the order? What is the order of BC now? Because they are in possession. Who's in possession? They are in possession. So order is to give handover possession to you, restore the land. Okay. Now possession is not given to you. We'll have this matter also on Monday.
They are filing the application for restoration. They are not.
Pikodi. Why you don't? Why can't you give copy to your friend? Madam, you fight the case fairly, not by deception. Not by deception. You should say voluntarily that you will serve a copy. Serve the copy today itself. The counsel for the petitioner to serve one set of copy to both the respondents. Who are the other respondents? Private Obrena, the Gapless government. To both the to the respondents during the course of day. Relist on 63. When the deceased has died. Only Obrena. Huh? Who are you? Purchase. So there are no LRs. Petition abates now. No, 2021, sir. We are already 2 years up. More than one year. December 21. At request of learned counsel for the petitioner, release this matter on 7th.
26,
My lord, with my lord's permission, my lord, I appear for the petitioner, my lord. My lords, in this matter, we are requesting for a week's time, my lord. There are certain office objections. We will attend to it, my lord. May I request my lords to kindly have it next week, my lord.
Request of learned counsel for the petitioner. A week's time is granted to rectify the objections. No representation, 2 weeks time granted if needful, done, issue notice. Same order.
My lords, I appear for petitioners. My lords, this matter and next matter, my lords, kindly pass over, my lords. I will withdraw both the matters, my lords.
All right.
That's also my lords.
29:30, you are appearing. All right. You want to withdraw, madam?
Please,
Do you
please,
have
my
any
lords.
objection? $78.
And 18.
So all these matters you want to withdraw?
Please, my lords. It pertains to the same parties, my lords.
All right, file a memo.
Please. Grateful, my lords.
All right, she is filing for withdrawal. You have any objections? Pass over.
Grateful, my lords.
What is the objection? Delay days ಹಾಕಿಲ್ಲ ನೀವು ಮಿಸ್ಟರ್ ಉಪಿನ್ ಮಹೇಶ್ ಕೊಡಿ. What is this matter pertaining to? Without hearing and then you ಬರ್ದಿದ್ರೆ ಏನ್ ಮಾಡೋದು? No, before this court you have not appeared. Recognition has been withdrawn. On what ground? Heard. Comment? R1 to R4. Heard learned counsel Mahesh R. Upin. He submits that he would rectify the objections raised by the registry during the course of day. Submission is placed on record and is permitted to do so. Matter is on IA number 1 is and 2 are heard. I have perused the application annexed to the application IA number 1 and 2. What is the delay? The reasons assigned and the cause shown in the affidavit annexed to these application are bona fide, genuine, and the same is accepted. As it is sufficiency of cause is shown, accordingly, delay of so and so is condoned. IA number 1 of 23 is allowed. Consequently, IA number 2 is also allowed. The order dated 3/8/2021 dismissing the petition for non-prosecution is recalled. The petition is restored to its original file. Then learned counsel for the petitioner to furnish one set of copy of the petition along with document annexures to the learned AGA. What is the number of days of delay? 7. It is allowed subject to payment of cost of. What is reasonable according to you? 5,000 rupees. 500 and then small causes court alle 500 ಹಾಕಲ್ಲ. ಯಾವುದು 1947 ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Your choice of 5,000 rupees or give the books of 5,000 worth to the advocate's library. All right. Pay a cost of rupees 2,000 to the advocate's clerk benevolent fund within a period of 2 weeks from today.
Anyone against?
2 weeks time granted if needful done notice to respondent. Yes, Kamaluddin. Paid. 1 week. A week's time granted if needful done issue notice to R2. Maybe Muniswami Gowda. In the transfer petition of original suit or who's R2? You are defendant. Do you have any objection in transfer? Yes. Give the order. Yes, Sharad Rao. Yours for the husband. What petition? So that's withdrawn. Now you are staying together. But Learned counsel for the petitioner has filed a memo seeking withdrawal of this petition. As not pressed for the reason that the parties have amicably settled the dispute. By entering into compromise by divorce petition mutual. In which petition? Submitted, the parties have entered into a mutual consent divorce petition in MC 290 of 2000. File a family court of Tumkuru. Hence, this petition would not survive for consideration. Accordingly, submissions of the petitioner and the memo placed by the petitioner, which is also signed by the petitioner, is taken on record. Petition is dismissed as not survive for consideration, as having become infructuous.
Later, my lord, they brings this on directed to post that matter. Because the challenge is the classification. So we first changed it to active. Then the action is raised. From the date of the award. From 2013, 2009 itself, we have filed the 2013, we appealed this one.
Appeal against second respondent is dismissed. Who is the second respondent? Owner cum driver. So the judgment and award which you are challenging is fastening the liability on you.
There's only financial they have shifted. Because there's no insurance during that time. So financial has been made a party and the liability has shifted over time.
No, the tribunal has fastened liability on whom? Tribunal fastened the liability on. That is you, appellant.
Financial, you are the finance.
You are the insurer.
We have finance.
What are the facts of the case? It's a motor accident. What are the facts of the case? The insurance is dismissed. You are not the insurer. Petition against insurance company is dismissed.
However, the liability shifted on the water. This is the three hypotheses. But in fact, they have shifted the liability on the bank.
So you are now seeking for recall of which order?
Okay.
Who appeals for the respondent? Abhi Shrikant avare bartaralla avare same. All right, any objections are filed? We'll have it next week. Let him file objections. The counsel for the appellant is present. There's no representation on behalf of respondent. Let's release this matter next week. The meanwhile, counsel for respondents to file objections, if any, to the applications preferred by the appellant. You have deposited. For the insurer, your Shivanda Gowda, you deposited that amount. I3 statutory gottaitu. Now, as per the order of this court, interim order was granted. Have you deposited? Not now. You have not till now. You are not deposited. ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ಲ ನೀವು ಕ್ಲೈಮೆಂಟಾ ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ಲ What is the interim order? Huh? When do you want? What is the time you want to do? What is the amount? 50. Have you read the order? Interim order is a copy idea. You also don't have copy of interim order. Okay. Withdrawal application ಹಾಕಿದ್ದೀರಾ? ಏನಕ್ಕೆ withdrawal? ಯಾವ amount withdrawal? ಅವರು ಸರಿಯಾಗಿದ್ದಾರೆ, ನೀವು ಸರಿಯಾಗಿದ್ದೀರಾ. And you blame the dependency to the court. You filed in 2022. Orders passed in 2013. You don't bother to check whether he has deposited. What is the application you have filed now? Barkoli. Please. Learned counsel for the appellant insurance company is present, so also learned counsel for the respondent number 1. Rajala, ನಿಮ್ಮ ಹೆಸರು? You also filed an appeal for enhancement. Respondent claimant, who's also the appellant in the connected appeal. Despite order dated 19/4/2013, wherein an interim order of stay was granted subject to deposit of 60% of the award amount, including the statutory deposit. Within 4 weeks, in said date, no amount has been deposited till date. Despite the amount not having been deposited, respondent claimant has filed an application on IA number 1 of 2022, dated 14 September 2022 for withdrawal of the amount in deposit. The said application, however, would not survive for consideration in view of the fact that no amount has been deposited. Application is dismissed. IA number 1 of 2022 is dismissed. Learned counsel for the appellant insurance company seeks time to deposit the amount as ordered by this court on 19/4/2013. 2 weeks' time is granted to deposit the said amount, including the statutory deposit. Failing which, list this matter for dismissal after 2 weeks on deposit of the said amount as ordered by this court on 19/4/2013, that is 60%. What is your appeal challenging? Liability andre? So your only ground is that he did not have driving license. Yaro, your vehicle driver, your insured vehicle driver did not have driving license. That's no ground. I'll permit him to withdraw the amount. No, entire amount. Sir, you're paying, you're only 60%. That is 60% of that amount. The respondent claimants would be at liberty to withdraw the entire amount in proportion to the judgment and award passed by the tribunal upon proper verification. Where are you directed to deposit? No such order is made. The amount shall be deposited before the jurisdictional tribunal. Dismiss ಆಯ್ತಲ್ಲ. No, already there is one more MFA. You want the records? Or the registry to secure the tribunal records, trial court records. Application is dismissed. On deposit, he shall be permitted to withdraw. That's a separate order. Yaudu? No, that we'll see. I don't know. Let it come. That's immaterial now. It's a DD file. Adin nodana barri. It's a DD anyway. It's not going to affect.
Number 38.
Oh, Mahesh.
Appear for the respondent, my lord. There is a delay of 937 days. Para 3, my lord, may consider, and he had entered appearance, my lord, in the connected matter. Para 3, my lord, does not disclose when the certified copy was applied, when it was received.
This is filed for enhancement. Filed for enhancement.
My lord, it is the owner's appeal, my lord. Owner's appeal.
So you have been exonerated in the.
But para 3 of the affidavit, my lord, supporting the.
No. What is the main order? Main order in the tribunal? What is the order of the tribunal? Dismiss. What is the main order, sir?
Yes, Lord. Lord, it was dismissed, my lord.
Why owner will come, sir?
Lord, he is the owner insured.
Claimant. Claimant's appeal.
He is the claimant, my lord. He is the owner insured.
All right.
Claim under section 163A of the Motor Vehicles Act. That came to be dismissed. My lord. On 19/2/2011. Now, para 3 of his affidavit in support of the lord application for condemnation of delay may kindly be looked into.
All right. There were other coordinate matters also.
Para 3, my lord.
Yes.
He said that, my lord, his advocate did not suggest him to file an appeal. And his relative, my lord, suggested him to file an appeal. And later he filed application for certified copy without no date. When he received the certified copy, he is also not forthcoming. And when he filed the appeal, he is also not forthcoming. Last time orally or suggested him to file a better affidavit.
Was he present on the last occasion?
Last occasion he was present.
There is no representation ಅಂತ ಇದೆ.
On 9/2/2023, my lord. He was absent, my lord, on 21/2/2019.
Already, last time you made a submission with regard to the other appeal which is tagged on with this. What is it? What's your submission?
He had entered appearance, my lord, in the other two appeals. However, para 3 of the, my lord, affidavit, he says, my lord, the advocate did not suggest to prefer an appeal. His relative of some time suggested to prefer an appeal. And thereafter,
what is the
he
relation?
filed the application for.
What is the relationship in that MFA 2230 and 2232?
My lord, he himself, my lord, he himself is the claimant, he himself is the owner insured. Claim is under section 163A.
No. You said that MFA 2230 had appeared. That is what was your submission?
But on 21/2/2023, he was absent, my lord. As per my noting, my lord. Orders to be called next week.
At your instance, this MFA number 2230, 2232, which is disposed of on 26/7, is tagged on with this.
He had entered appearance, my lord, he had knowledge. Apart
In the
from that,
MFA.
yes,
What was his position and rank in that MFA?
2230, 2232.
So he was respondent.
Yes, my lord, he was responding, he was served.
All right. Contested also.
Apart from that, para 3 of his affidavit, my lord, do not constitute either a sufficient ground or a good ground to condone the delay of 937 days. It's an appeal by owner insured, which he had made a claim under 160A was rejected. Along back on, my lord, on 19/12/2011.
So which was the vehicle involved in the accident?
But in his case, my lord, that he was the, my lord,
So he was a rider?
but issue number, issues frame, my lord, para 4 of the judgment. ಮಂಜುನಾಥ ಎಂಬುವರು ಏಕಾಏಕಿ ಬಂದಿದ್ದನ್ನು ತಪ್ಪಿಸುವ ಸಲುವಾಗಿ ಅರ್ಜಿದಾರರು ತಮ್ಮ ಬೈಕಿಗೆ ಬ್ರೇಕ್ ಹಾಕಿದ್ದರಿಂದ ನನಗೆ ಪೆಟ್ಟು ಬಿದ್ದಿರುತ್ತದೆ. ಇಟ್ಸ್ ಎ ಸೆಲ್ಫ್ ಆಕ್ಸಿಡೆಂಟ್.
Now the claim petition here and the others which are tagged on, they were all, there was a common accident.
It's a common accident, my lord, arising out of the same accident.
All right, the appellant claimant was a rider or pillion rider?
He was the rider, my lord, he was the rider, he was the insured.
Okay.
And the claim, other two claims were against.
Heard the learned counsel
He entered
appearing for the respondent insurance company. There is no representation on behalf of appellant. It is seen that the appellant has not been appearing in this matter since more than 2 to 3 hearings. However, the application IA number 1 of 2013 is taken up for consideration. IA 1 of 2013 is filed by the appellant seeking to condone under Section 5 of Limitation Act to condone the delay of 937 days in filing the above appeal. Filing the appeal. The reasons are assigned in the affidavit annexed to the application. I have perused the affidavit annexed to the application. You have not filed objections, Allah?
No, I have not filed orally, my lord, I have objected to it.
All. The learned counsel for the insurance company has vehemently objects to the allowing of the application on the ground that the reasons assigned in the affidavit annexed to the applications are far from truth, concocted, fabricated, in view of the fact that the appellant claimant was aware of the proceedings and he cannot take up the plea that he was not aware of the court proceedings and rules as he had participated in the other matter which was filed by another claimant in MFA 2232.
Para 3 of the affidavit.
232 of 2012, which has been disposed of by this court. Para 3 of the affidavit narrated by the appellant is not satisfactory and does not make out a cogent case of reasoning to be accepted by this court. Full stop. The learned the counsel for the appellant is also not present despite giving sufficient opportunity. Full stop. When an application for condonation of limitation is filed, generally the court is lenient to allow the application, also in cases of accident, road traffic accidents. But the fundamental rule of allowing the applications for condonation of delay is on the basis of sufficiency of cause shown and the reasons assigned by the claimant. No doubt, this court and the Honorable Apex Court has held in several judgments, including the judgments of Controller of So-and-so versus Katiji 1987 and Isha Bhattacharjee so-and-so, that a pragmatic view would have to be taken by the courts in allowing the application. Nevertheless, it is also mentioned that when the appellant or the person seeking condonation of delay does not satisfy the court with regard to the reasons for delay and sufficiency and cause for the delay, and slept over the matter like a cook, the same need not be allowed. The present case is one such case where the reasons assigned are not bona fide. The cause shown therein is not sufficient and cannot be accepted. Accordingly, I do not find any cogent reason to allow the application, as nothing is forthcoming to believe the version of the appellant as per the affidavit annexed to the application. Accordingly, IA 1 of 2013, seeking condoning the delay of 937 days in filing the appeal, is dismissed. Consequently, the appeal is dismissed.
See.
A week's time is granted to rectify the objections. We are fair, madam. Who appears? Narayana. Where is Narayana? You are appearing for whom? Where is this Narayanappa? ನೀವೇನಕ್ಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಿ? You know Narayanappa. Narayanappa is a counsel who comes to the court. Already inform him. You grant him 1 week. A week's time granted finally to the respondent number 6. He is appearing for R6. LRs of R6. LRs of R5 and R6 to rectify the objections raised by the registry. Failing which adverse orders will be passed on the next date, released next week. You are purchaser. Who appears for granting? No. If both of you want to argue the matter on whatever is listed, you can argue. What is this application IA for early hearing? Who wants to produce documents? IA 1 of 21 year file. Who was filed IA 1 of 19 for early hearing? I'll allow this application. What about IA 1 of 2021 for permission to production of documents? All right. IA 1 of 2019 for early hearing is filed by the advocate for respondent number 4. IA number 1 of 2021 is also filed by the advocate for respondent number 4 for production of certain documents. The said application, that is IA number 1 of 2021, shall be considered along with the main petition. However, IA number 19 filed for early hearing is allowed. This matter. When do you want Mr. Gangadhar Pandu? Tomorrow, Agalji. What is the urgent? You are for the grantee. What is the order? Now the order is in your favor. So you went before the AC, allowed, restored. So DCE was rejected and affirmed the order. Who's stopping you? Is there any order of stay? Stay order of what? Impugned order of stay, but prior to that itself, no. Impugned order of stay of the assistant commissioner. No, stay of which order, sir? Right, assistant commissioner's order granting you the restoring possession wherein you have been put in possession was challenged before DCE. He came before this court. This court referred it to the DC. This court must have referred to DC for exploring the appeal provision. Then what happened in the appeal? So the order of AC stands. Now he is before this court. The order of the DC affirming the order of AC is now stayed. Correct. Now you are in possession. All right. So what's your grievance now? Enjoy the property. By whom? We'll list it after 2 weeks and give a date and we'll hear it. List this matter on the 9th March. Both of you, meanwhile, you can prepare a brief 1-page or 2-page synopsis if you want. If you have already filed, share it before you file with each other. You can argue the matter on 9th. List this matter on 9th.
Srinivas.
You are a purchaser. You are a purchaser. No, you don't begin because she wants to file that. Let her file it. All right, I'll hear you. ನಿಮಗೆ ಇಂಗ್ಲಿಷ್ ಅರ್ಥ ಆಗುತ್ತೆ? ಒಂದ್ ನಿಮಿಷ ಇರಮ್ಮ, ನಿಮ್ಗೆ ಇಂಗ್ಲಿಷ್ ಅರ್ಥ ಆಗುತ್ತಾ? I'll fix it. Mr. Srinivas, fix a date, you argue, I'll give you sufficient time. Avaru madli, neeve madi. I'll decide the matter. 9th, I've already posted one. Posted the week after that, 15th or 16th. Learned counsel for the petitioner is present, so also party in person. Venkatamma has gave it a respondent 5. she requests time to file the translated copy of certain documents, which is permitted by serving the same to the other side, released on 15th March. Yes. Now, last time you submitted that you will consider taking the assistance of a lawyer. But what is what is your IA2?
I pay for R2, my lord.
You are ready to argue?
Yes, my lord. Yes, I am ready to argue, my lord.
One minute. You are also ready, Mr. You address argument in the afternoon. I'll finish the other list. You come at 2:30. You can address arguments on the main matter. Main matter, madam, first we have to decide whether your petition is going to be appreciated or not. If you do not make out a case on the main matter, the question of considering your IA doesn't arise. That is your problem if you have waited for 8 months. Now you argue the matter at 2:30 on your merits or even your IA. The petitioner is a. First, tell me some facts. Mr. Mohan, you're a seasoned lawyer. First, narrate some 2 sentences of facts and then come to the annexure.
As per Annex B, page number 43. Where now the natural need for proposal bullying. The several schools are converted under the register of proposal resources. Who meet under that that is called as CGST. It is equivalent to CGST. And this is that also we have obtained an approval certificate as per the read. Like ICRA International School, the certificate is given, and as per the website, our school is also mentioned. How can you see? In the main thread, Annex F 51. Earlier we have applied for the academic 2013-14 Kannada medium. The permission in the right of the constitution, all effect of the they are permitted English medium. So then the renewal of recognition is like a head. Page number 54. After building the
Yes.
they were the inspection and they issued the certificate in 2018. Thereafter, as per Annex J, dated 21, in 2021. The recognition certificate has been granted. As in following 2 years. The address is that 202. This school was instituted
Page?
your teaching central focus on update targeting September 9, 2021. This is which is under the British and the national work. This is to inform you that November 2000. They have been approved to offer our international travel and lower travel first level qualification in their schools. In India, also the 5 interest CGST subject are equal to 10. Total. Similarly, to not also then we also obtain an oil. I have seen also then page minus because I have 24 pages total. is dated 23/1/2023. ಇದರಲ್ಲಿ ಇಲಾಖೆಯಿಂದ ಶಾಲೆ ನಡೆಸುವ ಉನ್ನತೀಕರಣ ಸಂದರ್ಭದಲ್ಲಿ ಶಾಲೆ ನಡೆಸುತ್ತೆ. ಅದರ ಶಾಲೆಗೆ 2/2/28 ನೀವು ಅದನ್ನು the end of the academic year, already academic more, they are not also parents. But even though the teaching cannot different areas. Another aspect is this cycle was how earlier the school was in what now it is only the rate of giving the Act 2020. Then 243 what happens now? When much of that the what number building is there, same. Now the CRP that people because they are not teachers, government is teachers. They come and visit and they say you are shifted, you have to take again other official. So it is not a 50. It is the same same place. Everything what number is paid. Then for that we also given a clarification. Compensation we also given a space for yes. Coming from and also in working field. Essentially, we have to upload the details of the school. Page number 77.
The number
77. It has been uploaded under this page of the child in the upload. Today is number 4 is also given to our school. Next code we call it as. That is also there. School code. Name of cluster results is there. All the details are in submission. Oh, only my responsibility. Also, this is there.
Yeah. Yes.
Registration date 2017. That is all. That is Nano number 18. Registration date 8/70.
Yes.
This is uploaded and still active. That will find any fault because if you are changing my mother address. This system won't accept. Because already been there, already they also. So there are two issues rising. One is that you are not getting the approval for change of 9 to 10. That is our national opposition.
So this is for all this is for 1 to 8 standard.
Yes, sir.
Yes. So what is that now you are challenging? What are you challenging now?
Yes, they are issued a total notice. Parent ಈ ಏನಾದ್ರೆ ನೀವು ಅನಾಧಿಕೃತವಾಗಿ ಸಾಲ ಕೂಡಲೇ ಈ ರಾಜ್ಯಾಂಗ ಮಾಡಿಕೊಂಡಿದ್ದು this notice itself is very bad. I also given a reply.
So you want them to consider?
Let them, if I shifted to any
All right, I'll direct them to consider. Sir, what is your Mr. Mohan? The prayer is to consider your representation. I'll direct them to consider. You are now also conducting 9th and 10th. 9th and 10th standard also students are there.
First stage.
Where is that? Q. Page. Hmm. 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 Hmm.
Last paragraph.
Last paragraph.
He had moved the facts to accommodate our growth. Just say that again.
Hmm. Hmm.
Especially night then they are very kindly pass next year onwards. They have to take make a
Now the students of which classes are studying in here? Students of which class? Please answer the question of code. Students of which classes are studying in your school? Which class? 1, 2. Okay. So they are also studying now. 9 and 10 also are studying in the same school, same premises.
If I say
By whom? By whom?
That is, based on the approval of Consolidation of Indian University.
All right, you will not take any precipitative action to the students now presently studying. Yes. I'll dispose of Steph. I'll dispose of your petition. Hmm.
It is issued on 18th July. The certificate is powerful at the day. With reference to your application dated 7/4/2020. There's a few ways I mentioned. Now, recently, the what changes? It is for the BPP and the education department to anyway, my representative, let them consider my representation.
Heard counsel for the petitioner and AG for the respondents. Petition.
The right of payment for the minimum because the only thing is that they can.
But see a prayer in the writ petitions. Why are you here? Then you would withdraw your petition. You want to withdraw? Okay. In your prayer, you sought for consideration of representation. Let them consider and pass an order. If they pass anything contrary to the orders of the division bench, you can say so or give a detail, furnish one copy along with that with a few new representation. At the order madre, it will be in violation of that. Petitioner is a trust under the name and style of Universal Educational Trust. Which is running an educational institution in the name of IQRA, I-Q-R-A, capital C, International School with British Curriculum Accreditation. It's contended that it has obtained approval from EDEXCL, within bracket Pearson, which is also approved by Association of Indian Universities by letter dated 10/1/2019. The accreditation provided by the said EDEXCL Pearson is annexed as Annexure B. It is also contended that the Ministry of Human Resource Development has recognized the same as National Institute of Open Schooling and an autonomous institution. The Government of India has provided and granted the approval by issuing a certificate dated 21/10/2019. It's the contention of petitioners that the educational institution is recognized by Pearson, UK, based in London, within bracket registered in England and Wales. Conduct classes for 9th and 10th equivalent to CBSE. It's also the contention of learned counsel for the petitioner that the state of Karnataka, the government of Karnataka, the education department has given recognition to run standards 1 to 8 in Kannada medium for the academic year 2013-14, as per the recognition letter dated 1/3/2013. Issued by the third respondent, by Dana Sharif. Petitioner sought for recognition to run classes from 1 to 5 in English medium, which was approved by the third respondent by recognition. Third respondent by recognition letter dated 29/7/2017. Thereafter, the petitioner upgraded from standard 6 to 8 in English medium, which was also recognized, correct? It was also recognized. It is submitted that earlier the school was being run in the premises number 77, 36th Main Road, Dollar Scheme, BTM first phase, Bengaluru. Because of certain constraint of space, the petitioner institution moved to a bigger campus in the year 2014. To a new address, that is number 202, Second Cross, J. Bhimanagar, BTM layout, first stage, Bangalore. This first stage. But they have taken in para number 5, page 6 of their petition. Petitioner submits that this being the state of affairs, third respondent issued a show cause notice on 10th August 2021. That the petitioner is running a school which is unauthorized for the 9th and 10th standard. It is a contention of petitioner that the petitioner has obtained the clarification letter issued by Pearson to the third respondent by letter dated 9/9/2021, which should show that the 9th and 10th standard is equivalent to 10th grade pass and at international advanced level are equivalent to 12th grade pass. This being the state of affairs, the petitioner was in shock to receive a show cause notice dated 23/1/2023 as per Annexure Q. For having shifted the school premises from the previous premises, to which the petitioner had given a reply to the respondents, which has not been considered. Despite the issuance of a reply along with all material documents for having obtained the recognition and running the school in accordance to the certification of recognition and grant of approval by the state as well as the central government. The respondents are 3 and 4 are harassing the petitioner, close down the school. It's also the contention of petitioner that petitioner institution being a minority school institution, they have uploaded the SATS details by showing the address of the school along with the students. In view of the show cause notice issued by the respondents for alleged to be running the school in an unauthorized manner, petitioner is before this court, seeking for an order from this court to direct the respondents to consider the representation made by the petitioner, along with the documents and the latest judgments of the this honorable court in the case of which is the judgment of this court relying TMA pi? Judgment of this court, or you're relying on TMA pi? But the judgment of not this court, judgment of the Honorable Apex Court in TMA pi Foundation case, reported in AR 2003, SC page 355. Learned AGA representing the respondent contends that the petitioner school was initially run in a different location, which is admitted by the petitioner himself in para number 5 of the petition, and thereafter they have moved into a bigger campus in the year 2014 to run the educational institution for 6th to 8th standard, from 1st to 8th standard. Full stop. However, while shifting the school from one location to the other, the rules and regulations and the act mandates that the petitioner will have to seek approval and recognition. The same has not been done. Hence, the review notice has been issued to the petitioner to seek the necessary approval for having shifted the premises from the previous location. It is seen that the petitioner has replied to the notice. You have replied, Allah, to the show cause notice issued by the respondent by producing all relevant material to show that there is no unauthorized running of the school and it has been done on proper recognition and approval granted by the state as well as the central government by obtaining proper minority status from the concerned National Minority Commission. So he has produced those documents. He stated in the application, this petition also. So that you consider that's his contention. All right. Be that as it may, the notice. Be that as it may, the notice issued by the respondents have been suitably replied by the petitioner. The present writ petition is filed to consider the representation along with documents filed by the petitioner institution to the respondent state. And respondents 1 and 2, na? One and two. Who has to consider, madam? 1 and 2. 3 and 4. One minute. Madam, writ of mandamus is seeking to consider the representations of 1 to 23 to both third and fourth
the problem.
Because the annexure R and S and T and U are given to 1, 2, 3, and 4. So respondents 1 to 4 have been provided with certain representations dated 1/2/2023 by the petitioner, which requires to be considered, and suitable order needs to be passed. Accordingly, I pass the following order. A writ of mandamus is issued to the respondents 1 to 4 to consider the representations of petitioner dated 1/2/2023 by annexure R, S and T and U. Correct? R, S, T and U. S, T and Q to be considered in accordance to the addressing of the said letter to the respective respondents. The said consideration of the representations shall be made by the respondents within a period of 4 weeks from the date of receipt of copy of this order. In the meanwhile, it is made clear that the students studying in you will not disturb their education. In the meanwhile, the respondent state shall not disturb the education of the career of the education of the students for the academic year, the present academic year 2022-2023, as the students are in their elementary school as well as in the 9th and 10th standard, including the students of 10th standard taking up the board examination, which will affect their mental status if there is any hindrance by the respondent state. Okay. That is for him to take. That is not before me. I've said so 22-23. For next academic year, he's at liberty to file if he requires. You are at liberty to cancel if he doesn't have. That's not before me now in this petition. Petition is allowed according. Where is petitioner? Stay is granted. There is no representation on behalf of petitioner. Learned counsel for the respondent is present. Relist this matter next week in order to continue, if any.
44, my lord, I am representing.
Sorry,
my lord.
Order pass आदमेल बोल रहे हो
I'm sorry, my lord, I was under, there was a disturbance, my lord.
Yes, you are ready.
My lord, it's a case where, my lord, the MC petition is already filed before the family, Bangalore city. My lord, in spite of it, my lord, they have filed another JNWC petition at Kunigal town, my lord. Therefore, my lord, I sought for transfer of that JNWC petition to this Bangalore city only, my lord. Because there is already a divorce petition is filed by the husband.
Who was filed this GNWC 10?
Not he only, my lord, husband only.
Why you have gone? Where are you staying?
My lord, he is in the city of Bangalore.
Where are you staying? Why did you go and file a custody petition in?
He filed a petition.
What happened to MC 74?
Still pending.
Withdrawn by you from Bangalore court. Now you have filed one more petition. Delhi. 2582 of notice is gone in that.
They are not fair, but now when sometimes they appeal because the expert order, but they are not
All right. Now, why you have gone and filed the petition for custody in Kunigal when you are residing in Bangalore?
they declared is in Kunigal, maybe of better
All right, you conduct together all the cases. Maybe you can't come on.
No,
You are not. Why you are not sought for the prayer?
please, Manad.
You are not aware of that MC 2586.
Yes, Manad. Recently, I came to know of that, Manad. I filed necessary application for setting aside the order of ex parte, Manad. That is pending before the family court only, Manad. In spite of that, Manad,
That is pending or allowed? Ex parte is allowed or you are not aware. You are not aware that the ex parte is already set aside and you are conducting the case.
No, I've been called for to file objections, Manad. At that point
Why
of
you are not amended this petition?
Manad, I'll verify that records, Manad.
What is your prayer here?
Here, Malad, they sought for in the JNWC. In this petition, Malad, I sought for Malad to transfer of this petition of JNWC from Kunigal to Bangalore.
Along with, we tried along with what MC?
And earlier MC, Malad, now it has been renumbered as another petition has been filed. I'll make corrections in the petitions, Malad, and seek for all the very prayers which have been sought before the court.
You should have done that.
Malad,
When did you withdraw that MC 74 of 21? Twenty-three. 23/3/2022. All right. So you have no objection. You come on.
please.
Lenara ಮಾಡ್ಕೊಳ್ಳಿ. Come and carry out the correction.
I'll do it, Manad. Carry it.
Order sheet Learned counsel for the petitioner, Sri Sadashivaya KG, permits that during the pendency of this petition for transfer of matrimonial proceedings of MC number 74 of 2021, of GNWC 10 of 2021, to be tried along with MC 74 of 2021. The respondent husband has withdrawn the matrimonial proceedings MC number 74 of 2021 pending on the file of second additional principal judge family court of Bengaluru on 23/3/2022, and thereafter referred a fresh petition in MC number 2586 of 2022. This being the state of affairs, petitioner seeks leave of this court to make corrections in the to transfer the GNWC case that is pending in which court?
Kunigal.
2586 in first additional to transfer the custody petition filed by the respondent husband to the first additional principal family court, Bangalore, correct? First additional principal, first additional family court, Bangalore. Same is permitted. The petitioners shall carry out the necessary corrections to which the learned counsel for the respondent does not have any objection. For correction.
Please.
Yes, the petition is allowed. The matrimonial proceedings in GNWC number 10 of 2021 pending on the file of senior civil judge and JMFC Kunigal, referred by the respondent husband, seeking for custody and guardianship of the minor children,
Minor child.
Is ordered to be transferred to the first additional family court at Bengaluru to be called and tried along with MC number 2586 of 2022, preferred by the respondent husband and the said court, the said family. Accordingly, petition is allowed.
Great.
Orders to follow. You are objecting or you want to consent? You would object or you want to consent? If you have any difficulty, I will say you are not agreeable and vehemently argued. All right. Learned counsel for the vehemently objects to the said transfer on the ground that he is the permanent resident of Kunigal. Respondent, resident of Kunigal and permanent resident of Kunigal. Accordingly, he had filed the custody petition at Kunigal as his parents are also residing in Kunigal, and which would be the better place for taking care of the minor child. Therefore, he objects to the contentions raised by the counsel for the petitioner, and the distance between Kunigal and Bangalore is 70 kilometers, which is not much of a distance, and he would bear the transfer expenses.
No, my lord, unnecessarily, my lord. She is the permanent resident of Bangalore only.
And he would bear the expenses of transfer, transportation and food and nourishment to the petitioner if she travels to attend the case at Kunigal. All right. This will be incorporated.
My lord, may I submit, my lord? My lord, in fact, my lord, she is not the permanent resident of Kunigal at all. The petitioner is concerned, and a small child is there, my lord. He is the only daughter to the parents. My lord, she alone has to travel from that. My lord, there is a threat. Threat was also there. But therefore, my lord, we requested your lordship to be kindly be passed to the Bangalore city only. My lord, she can as well travel to the Bangalore city only. And the person.
Oh, heard the order. You have heard the order.
Yes.
Have you heard the order? You are able to hear the order.
I couldn't. Sorry, my lord.
ಇಲ್ಲ ನಿಮ್ಮ ಆರ್ಡರ್ ನಾನು ಮಾಡಿದ್ ಕೇಳಿಸುತ್ತಾ ಇಲ್ವಾ?
There was some disturbance, my lord.
I have allowed your petition of transfer.
Please, grateful.
You have to carry out the correction, Mr.
I'll do it. Today it only I'll do it.
Itself you will have to do.
Please, my lord.
There is your friend who died. This is also matrimonial proceedings. Huh? You have a stay. Stay to continue. Petitioner counsel is present. There's no representation for respondent. We listen. Week after next.
They don't have objection to
Section 12(1) is filed by you. What have you filed? Ilri avuru. Don't agitate there. So you want transfer from where to where?
From Bangalore to Shimoga.
Hmm.
The request is to directly Shimoga.
You both may not have objection. I have, and the learned judge will have. As it is, he will have so many direction matters of old cases, sir. Yours is 2022. If you cooperate, you expedite the matter. I will say expedite. You want to consent, or you want to also say you're objecting?
No, I object. They have already filed the 2 cases.
No. In this, whether you want to consent or you don't want to consent, I'll pass. Say, like previous case, that you want to vehemently object and then allow the petition. Same. Petition is allowed. Matrimonial proceedings and MC number 5570 of 2022 filed by the respondent husband. Pending on the file of 6th Additional Principal Judge, Family Court, Bangalore, is ordered to be transferred to the Family Court at Shimoga. Anything you have filed there? Restitute. MC? Birth code. That is pending in which court? Be transferred to Principal Family Court at Shimoga. We tried along with MC number so and so, wherein the petitioner wife has preferred a restitution of conjugal rights petition under Section 9 of Hindu Marriage Act. That is also in the same court.
Yes. All 3.
Since the petitions preferred by the petitioner wife for restitution of conjugal rights and the maintenance application under Section 125 CRPC is pending before the first additional Principal Family Court at Shimoga. The matrimonial proceedings in MC 5570 will be transferred to the very same court to be tried together. All right. There is a learned counsel for the respondent vehemently objects to the contentions put forth. When is the next date of hearing? 1/4. It is made clear that we are the fact that the parties to the proceedings are represented and appearing before the first additional, before the Principal Family Court at Shimoga in the connected matters as stated above. The parties shall appear before the Principal Court Shimoga on 1st April 2023 without awaiting any further notice from the family court at Shimoga with regard to the transferred matrimonial case number 5570 of 2022, referred by the respondent husband. Petition is accordingly allowed. Then the judge of the family court is requested to expedite the matter for disposal. It is requested to speedily dispose of the matter. The party shall cooperate for the speedy disposal of it. Yadu, you are not informed. You have an interim order in this case. It is extended. Correct. The order was to be extended. Correct. You have an interim order. All right. I'll extend the interim order. You argue on the next date. You bring it to the notice of the court on the next date that they have not informed you. Interim order extended. Yes. So you have filed for divorce. The respondent husband is filed for restitution. You are a resident of Kundapura, and the respondent is from Bangalore. She working here, or she's gone to Kundapura.
Was asked to become a job itself. She was a housewife there. You are running for she was asked to do a job. And they did this thing and they stopped inside together from 2022. Both places, Pakistan has been filed for mediation. They have come together and
So you don't want to join your husband?
all
right, I'll allow the petition. Heard. So petition is allowed. Matrimonial proceedings in MC 4771 of 2022 on the file of Court Additional Principal Judge Family Court, Bengaluru, is ordered to be transferred to the Senior Civil Judge Kundapura to be heard and tried along with MC number 185 of 2020, referred by the petitioner wife. When is the date of hearing there? The learned counsel for the respondent vehemently objects to the contentions of the petitioner to transfer the case as at the time of filing of the petition by the respondent husband. the petitioner wife was residing at Bangalore and working and residing at Bangalore. Subsequent to the filing of the petition, she has moved to Kundapura, and the arguments put forth for transfer is not valid. It's only to harass the respondent husband. However, the fact remains that the petitioner wife is residing in Kundapura as of now, and she has also initiated a divorce proceedings at Kundapura before the senior civil judge Kundapura. That is in MC 185. In MC 185 of 2022. Full stop. Accordingly, petition is allowed. Yes, Girish. Stay the distance. Stay there. Earlier. Next date. He's not here today. Learned counsel Sri Girish is present before the court for the petitioner. There's no representation on behalf of respondent. Release this matter.
In this case, I am for respondent, my lords. Which time may be granted to file the statement of objection, my lords?
Yavrali.
CP 27 of 2023, my lords.
No, I'm calling 51 serial number.
No, sorry. Sorry.
Release next week. Next week will birth. Date ಕೊಟ್ಟು too much of importance ಆಗುತ್ತೆ ನಿಮ್ಗೆ. Special consideration. ಅದಕ್ಕೆ ಬರುತ್ತೆ. It will come. Interim order extended till next week. Girish, she seeks time. You have stay. Learned counsel for the respondent seeks time. Counsel for the petitioner is present. Interim order is extended. Released next week.
Much obliged.
ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳ ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ಯಾರದು ಲಕ್ಷ್ಮೀ ನರಸಿಂಹಯ್ಯನ ಬರ್ತಾವ ಟಿ ವೆಂಕಟೇಶ್ ಎಂ ವೆಂಕಟೇಶ್ ಓ ಮಹೇಶ್ interim order extended till next date. Serial number 55.
Oh. ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಇದ್ ಮಾಡ್ಬೇಡ್ರಿ.
Real number. You are for the appellant. Hospitalized. At request of counsel for the appellant. We list this matter next week. Hi. You are respondent. You respondre alla. Why? You are for whom? Yaro. Huh? Insurance. Where is Suresh Latour? Next week, Akana. You can take down the file and argue and see. Learned counsel for the respondent number 2 seeks time on the ground that he's misplaced the file. Release this matter next week. Inform him so that he doesn't wait. No. No. Right? Not well. Who's the respondent? 2013 in the amount ille idra avarge ಏನು ಆಗಿದೆ? You want to shift the liability on the owner? On what ground? $65 ಅಲ್ಲ. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲ. ನಿಮಗೆ ಟೈಮ್ ಬೇಕೇನು? ನೀವು ಕ್ಲೈಮೆಂಟ್ಗೆ. You take it. Counsel for the respondent 1 and 2 claimant seeks time. Same is granted. Release this matter next week. Huh? Your appellant. At request of learned counsel for the appellant, matter is adjourned to next week on the ground of her throat infection to the learned counsel. In all the matters you are filing? All these matters are arising out of the same suit. All right. You have no objections. Okay. Counsel for the petitioner, Srimati Sadhana Desai, files a memo seeking withdrawal of this petition. Memo is placed on record, so also our submission. No objection for withdrawal by the learned counsel for the respondent. Accordingly, the petition is withdrawn. All cases. AGN. Learned AG, you have filed Vakalatal, Villa. Filed. Learned AG accepts notice for HCGP. In all the cases, respondent number 1 is from 104 is permitted to file wakalat within a period of 2 weeks. 2 weeks. Why you need so much time? Within a period of 4 weeks from today. Where we stop? I don't know.
His name? The invitation would be?
Mahesh.
Yes, my lord, I appear for respondent number 2.
Where is Venkatesh Murthy? There is no representation on behalf of the appellant. Learned counsel for respondent number 2 is present through video conference. Release this matter next week.
Please.
Mr. O. Mahesh.
Yes, my lord.
Why are these lawyers in MVC cases MFA not appearing?
My lord, too many courts, my lord, that's the problem, my lord. Nearly 4 courts are posted with.
dispose ಮಾಡ್ತೀವಲ್ಲ.
Now we try to, my lord, as far as possible to.
I've been seeing it's. I know there are other courts also, division bench and other courts. Keshav Prasant, BL Kumar, All right, none appears in these matters. We list next week. 58, you're ready.
58, I am ready, my lord, but it seems, my lord, it is connected with MFA 5989 of 2013. I had to check up and.
It's listed today.
I don't think so, my lord.
ಅದೇ ಕೆಳಗೆ ಕನೆಕ್ಟ್ ಆಗಿದೆಲ್ರಿ
Connect
ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಇಲ್ವಾ
ಕಾಲ್ ಲಿಸ್ಟ್ ನಮ್ದು ಪ್ರಿಂಟ್ ಲಿಸ್ಟ್ ಅಷ್ಟೇ ಬರುತ್ತೆ.
It's connected and it's placed before the court today. You're ready to argue?
1 minute, my lord. 58. Ah, 58, my lord. Mr. Nagaraj Reddy has also filed an appeal, my lord.
You're Nagaraj Reddy. He's here before the court. He's ready.
Yeah. I am ready, my lord. I am ready.
Argue.
But appeal by the insurance company on question of liability.
Yes.
But it's a case of death of one Mr. Ajay, aged about 36 years, earning rupees 10,000 per month, my lord. And said to be a cleaner under the insured. But the first respondent, my lord, SMD Salim was the shown as, my lord, owner and insured. He has been placed ex parte.
Owner is ex parte.
Ex parte. The appellant, my lord, was arrayed as second respondent, denied its liability on the ground, my lord, that he was a passenger and not an employee of the insured. He was, my lord, the deceased was traveling on the sand loaded on the lorry, my lord.
So your case is the deceased was an employee.
But first thing, my lord, he is a gratuitous passenger. Risk is not covered. And they claim, my lord, that he was a cleaner, and that is not being proved. And moreover, he was traveling on the sand load. Therefore, my lord, such a risk is not covered under the policy even otherwise.
Which is the vehicle involved?
The lorry, my lord. And alternatively, my lord, it has been pleaded that even if you were to be construed as a cleaner, but then the computation of compensation should have been under the provisions of the WC Act, not as a third party.
What is the case of claimant? Whether he's cleaner or what was he?
Well, he was, my lord, married, my lord. First petitioner is the wife. Second petitioner and third petitioner, son and daughter and son. Accident, my lord, is of the year 2010 at 9:30 p.m.
Yes. Yes.
My lord, it's an admitted fact, my lord, that he was traveling on the sand load, which capsized, and thereby, my lord, he succumbed to the injury sustained thereby. In this respect, my lord, I invite your lordship attention to the grounds, my lord, which have raised. Rule number 2, 3, and 4. Then, my lord, I invite your lordship attention to, my lord, the reasonings of the tribunal. Ink page 10, my lord. The issues framed at para 5. Issues framed, my lord, reads as under. Whether the petitioner proved that the deceased Ajay died due to rash and negligent driving of the lorry bearing registration number KA 403561 by its driver. Whether the petitioners prove that they are entitled to compensation of ₹10 lakh from the respondents. Whether the respondent number 2 insurance company proves that it is not liable to pay compensation. Whether the petitioner proved that the respondent number 1 and 2 are jointly and severally liable to pay compensation. These are the issues, my lord. Then the reasoning, my lord. Para 7. The petitioner to prove that the death of the deceased Ajay was due to rash and negligent driving of lorry bearing registration number KA 40 3561 by its driver have examined PW2P Yellappa. It is the evidence of PW2P Yellappa that he filed complaint in crime number 16 of 2010 in Gonipalli police station regarding the accident. He was traveling in the lorry in question towards Srinivaspur from Gonipalli to meet his relatives. When the lorry reached near Kalangadi cross on Bangalore Kuduppa road at about 9:30 p.m., the driver of the said lorry was driving the same in high speed, rashly and negligently. When the driver tried to take turn towards Srinivaspur road with the same speed, he lost control and the lorry capsized. PW2 Yellappa is cross-examined by the learned counsel for respondent. In the cross-examination, it is elicited that Redappa was driving the lorry in question. Redappa and himself were in the cab of the truck. Deceased cleaner Manju and 2 more persons were sitting in the said truck. It is submitted that the learned counsel for the petitioner and the evidence of PW2 clearly established that the accident was due to rash and negligent driving of the truck by its driver. As against this, it is submitted by the learned counsel for the respondent that the evidence of PW2 cannot be relied upon. It is pointed out that Exhibit P4 complaint filed by PW2 Yellappa, as can be seen from the allegations made in Exhibit P4, one Nazir Ahmad was the driver of the truck. Driver also not substituted. Similar is the contention taken by the petitioner in the petition. Therefore, this evidence cannot be acted upon. PW4 is the complaint, as rightly pointed out by the learned counsel for the respondent that in the complaint, one Mr. Nazir Ahmad is shown as driver of the vehicle in question. Exhibit P1 is the charge sheet. Charge sheet is also filed against M. Nazir Ahmad. The accident has taken place on 3/4/2010. This witness was giving evidence on 7/9/2012. It is possible that due to lapse of memory and in confusion, he has stated that Redappa was driving the vehicle in question. But as can be seen from the document, it is Mr. Nazir Ahmad who was driving the truck at the relevant point of time. It may also be mentioned here that the truck capsized the side of the road. In this case, the principle the reciprocity is applicable. Even in the absence of evidence of any eyewitness, the documents or record clearly speak about the rash and negligent driving of the driver. Not this, on this fact, my lord, the tribunal holds that it is affirmative on issue number 1. Your Honor, kindly consider, my lord, PW2 who gave the complaint says, my lord, one Mr. Nazir Ahmad and the driver name, my lord, substituted by the my lord Redappa. So this goes, my lord, whether the veracity of this witness can be, my lord, by. Then I'll further.
Yes.
Issue number 2, my lord.
No.
It is a case of petition that deceased was cleaner of the lorry in question. In this case, it is not disputed that the respondent one is the owner of lorry. He is the best person to deny the contention or to say whether the deceased was a cleaner of the lorry in question or he was gratuitous passenger. Respondent one has not appeared before the court and hence he has been placed ex parte. According to the petitioner, deceased used to work as cleaner in the lorry in question and during the spare time used to do agriculture, milk vending, sericulture, so on so. However, no documents are produced to prove the same. Petitioners have not examined the respondent number 1 to prove the income. In spite of this, my lord, the tribunal holds, my lord, that he was a cleaner under the insured. And wages, my lord, is taken as 200 rupees per day. But here, my lord, I would like to make a submission to your lordship that any person who was traveling in a transport vehicle in any capacity has to travel in the cabin, not on the load. Here, my lord, it is clearly stated that he, along with 2 others, were sitting on the sand load.
Really there.
Yes. But ink page 9, my lord.
In page 9 of
Exhibit P4, my lord, may kindly be looked into.
records is here. They're admitting. All right, he's admitting it. Yes.
Yes.
Sitting on the load of sand.
Yeah, but the risk of any person being carried outside the cabin is not covered. And it is stated, my lord, that the deceased and 2 others were traveling on the sand load.
Yes.
And there is no evidence or material to show what happened to other 2 persons. So my respectful submission, my lord. Even otherwise, the relationship of my lord, employer and employee is not proved. The court also, my lord, observes that no document is produced to prove that. Under the Minimum Wages Act, my lord, section 18 and rule 29, a transport vehicle, my lord, owner has to, my lord, maintain the register, name of the employee, and the payment, my lord, made towards the wages of those employees. Even in this case, my lord, when the respondent number 1, my lord, the owner remained absent, they are not, my lord, chosen to examine this witness by summoning him to say whether this deceased was an employee under him as a cleaner. It is very, very easy for them to say, my lord, that he was a cleaner under the insured. And it is also claimed that he was an agriculturist, sericulturist and all that. That itself or not creates a doubt whether he was really a cleaner under the insured first respondent who was placed ex parte. The one who comes to the court, my lord, has to discharge their owners by providing, my lord, both oral and documentary evidence. In this case, my lord, they are not chosen, and the court also observed that no documents are being produced. Even then, my lord proceeds to, my lord, to quantify. But my respectful submission is, my lord, even for a sake of, my lord, this thing, if he is construed as a cleaner, computation of compensation has to be under the provisions of the Workmen's Compensation Act, not as a third party. In this case, you have to kindly see the loss of dependency is 7,20,000, consortium 10,000, loss to the estate 10,000, 30,000 transport, burial and obsequies. This does not arrive. The tribunal has misled itself totally as to the facts and the position of law. Therefore, my lord, the appellant is before lordship in this appeal.
Yes. That's all.
Yes.
You speak on the mic so that we can understand and listen to what you're saying. That's the case of respondent. That's your case. Redappa and PW2 were sitting in the cabin. The complainant. No. Read cross-examination of PW2. Okay. You said that sir, you just now read Redappa was driving the vehicle. Earlier to that, Redappa was driving the lorry. Yeah. Redappa. What is his statement? FIR charge sheet agideyalla. Charge sheet witness iವರು ಇದ್ದಾರ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ. He must have given a statement before the police. Hmm. Hmm. ಏನು Okay. All right. Next. Hmm. Hmm. What is the income taken by the tribunal? What is the chart value? Hmm. What are you seeking enhancement? How old was he? 36. As per? And what is the basis of taking 36? You have stated yourself. Then how can you be wrong? Here, if you are stated that you are, I don't know, then you can come to the postmortem report, says 36 or 35.
Exhibit P3, the postmortem.
Correct, but you have not placed any other material to show he is 35. But you yourself have stated you are 36. Hmm. Correct, because of your own statement, you are the best person to say so. Age 36. So 40% will have to be added. Hmm. ಮೂರ್ ಜನ ಇದ್ದಾರಾ? ಏನು? Hmm. Yes. No, your arguments are main is, that's all. With other heads. ಯಾರು ಹೇಳ್ಬೇಕು? ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾರು ಮಾಡ್ಬೇಕು? ಕೊಟ್ಟಿದ್ದಾರಾ? ಮತ್ತೆ ಯಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು? ನಾವು ಪ್ರಾಂಪ್ಟ್ ಎಷ್ಟು ಬರ್ಬೇಕು? ಇಲ್ರಿ, ಕನ್ವೆನ್ಷನಲ್ ಎಷ್ಟು ಹೆಡ್ ಎಷ್ಟು ಬರ್ಬೇಕು? Plus 30,000. That's all. Ready? So relying on some judgment. ಎಲ್ಲಿದೆ ಅದು? ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ. Right, but workman compensation ಬರಕ್ಕೆ ಚಾನ್ಸ್ ಇಲ್ವಲ್ಲ. ನೀವು ಅವರಲ್ಲ ನೀವು. He is not admitting that fact. Mahesh is not admitting the fact that you are a cleaner. Are you admitting, Mr. Mahesh?
No, my lord, I am not admitting, my lord. My submissions, my lord, are threefold. May I invite your lordship attention, my lord, at this point of time, the complaint of my lord Yellappa. I just, my lord.
One ನಿಮಿಷ, let him finish, then you can reply. Yes, what do you want to say in this? 2000? ಯಾವಮ್ಮ ಕೇಸಲ್ಲ? Yes. Correct, but who's disputing that now? He's not saying that he should come under employees' compensation. ಏನಂತ? You have the liberty to file under both the enactment. Whichever enactment you file, it has to be considered under that enactment. So that is Devamba's case. Next. Yeah. 2018. Yeah. ಯಾವ ಕೇಸ್ ಹೇಳ್ರಿ ಶಿವರಾಜ್? ಎಸ್. ಏನ್ ರಿಕವರ್ ಆಗ್ಬೇಕು ಅಂತ ಪ್ಯಾರಾ 9 ಇಲ್ಲ. So you have also relied on 2 more judgments. They may suggest so many things. You have to prove your case by your own standing. What are these other 2 judgments? ಇನ್ನು 2 ಯಾವುದು ಕೊಟ್ರಲ್ಲ ನೀವಲ್ಲ? Madam, what is this? You relied on only 2 judgments. What is this 2006 Saira Devi? Huh? Have you relied on any judgment, Mr. Mahesh?
Yes, my lord. Case of National Insurance Company versus Chollati Bharatama, reported, my lord, in ACJ 2007, page 268.
Have you filed it?
Lord, it was once given. I got a copy, my lord. I don't know whether it is available in the file, my lord.
National Insurance Company versus?
Chollati Bharatama and others reported,
Chollati Bharatama. 2000?
Reported in ACJ 2007, page 268.
That Bharatama's case. It's not here. What is the ratio?
With reference to, my lord, section 147, the coverage, and held that, my lord, thing, and any person being carried outside the cabin are not covered. The carrying capacity of the vehicle, my lord, of a goods transport vehicle, the cabin capacity is important. Here, my lord, admittedly, the complaint of my lord Yellappa shows, my lord, he was in the cabin, and Ajay and 2 others, my lord, was on the road, sand load.
All right. Even if I accept your argument, it will be that you may have to pay and recover.
The question of pay and recovery does not come because initially, my lord, there is no coverage at all for such person under section 147.
Yes.
That one thing, my lord. And whether the complaint, my lord, shows that he says, my lord, who was driving the vehicle specifically. The complaint, my lord, given on 3/4/2010 itself at 11:40, whereas the accident, my lord, is said to be at 9:30 p.m. There cannot be, my lord, anything. So here, exhibit P4, my lord, clearly say that, my lord, who was driving, Nazir Ahmad was driving. It is their document, my lord, exhibit P4, P5, P6, everything.
All right, that is now no quarrel on that because he's admitting to the fact that the deceased was traveling on the sand.
Yes, my lord. Therefore, my lord, the Chollati Bharatama case, my lord, squarely applies. In whatever capacity, my lord, even if he's a owner, he cannot travel on the load.
All right, he has relied on the judgment of Shivraj versus Rajendra, 2018 Supreme Court. That is pursuant to your Chollati Bharatama Chollati case.
Yes.
And there are series of judgments after that. Manora Khatun's case. Pay and recover.
Look, pay and recover, my lord, is one thing. If it is a violation, my lord. When the risk itself is not covered, then the question of, my lord, does not pay and recovery does not arise. And moreover, my lord, one of the most important thing is, even, my lord, if your lordship consider him as a cleaner, the computation has to be under the WC Act, not as a third party claim.
Right? And how?
Yes, my lord, because he claims to be the, my lord, cleaner under the insured. He is a workman.
Maybe, maybe, if he's claiming so, you have denied it.
No, my lord, option to claim, my lord, maybe before MACT or before the commissioner. But the liability of the insurance company, once they claim that he was an employee of the insured, then, my lord, it is under the WC Act.
No. That analogy cannot be drawn. It is only the statement that incidentally he was a cleaner, employee of the owner.
Incidentally or accidentally, whatever it is, my lord, once he's a cleaner, then the
No, he has the liberty to claim under the workman's compensation.
That is only the forum, my lord. It is only the forum, but not the, my lord, this thing.
All right. Yes, that's all.
Yes, my lord.
All right, you have to read that judgment of Shivraj. Facts of the case are similar. Para number 9 and 10. He was also traveling in the tractor. And the point which you have urged is considered that a passenger, even the tractor could accommodate only one person, namely the driver.
Yes.
Insurance company not liable for loss of injuries. Conclusion reached by the High Court is unacceptable in the fact situation. That is what the Supreme Court has held.
But there, my lord, the carrying capacity has not been construed, my lord.
No, it's considered.
Here, my lord, in the.
Thus, it would follow that the appellant traveled in the tractor as a passenger.
But
even
I'll make a general submission, not so far as tractor trailer is concerned. Tractor, my lord, only driver is permitted. Trailer, my lord, has to be registered separately. There is no carrying capacity for the trailer.
Sir, it is considered in para 9. You have to challenge.
My lord is saying that.
Challenge the judgment of the Supreme Court.
But, my lord, if it is construed to be a passenger vehicle or a commercial vehicle, then 100 of the, my lord, Karnataka motor vehicles rule is applied to see some relief is given to the, my lord, the claimants.
No, that will not apply here. It's a tractor.
And therefore, my lord, my respectful submission, here he claims to be a cleaner.
All right, what is your argument that no liability on you?
One, my lord, because he was carried on the sand road, no liability. If for any reason, my lord, I am to be held liable, then the computation of the compensation has to be under the WC Act.
All right, I will consider your argument.
Yes.
Barkoli. These two appeals are preferred by the insurance company as well as the claimant, questioning the impugn judgment and award passed by the Second Additional District Judge and Motor Accidents Claims Tribunal at Kolar, in short referred to as Tribunal, in MVC number 131 of 2010, dated 21st of December 2012. Full stop. The insurance company is in appeal on the ground that the judgment and award passed by the tribunal is perverse, arbitrary, illegal. The same requires to be set aside, as the tribunal has lost sight of the fact that the deceased was traveling on the load of sand in the tractor, which is impermissible, and so also the policy does not cover such a person.
With your lordship's leave, my lord, I would like to invite your lordship attention to section 147 particularly. Lord, kindly, my lord, bear with me and.
Sure, why not?
Yes, 147, requirement of policy and limits of liability. There,
I've read it several times, but we will read again.
Yes, my lord, every time we have to.
Yes.
Yeah. Provided that the policy shall not be required to cover liability in respect of death arising out of and in the course of his employment of the employees of the person insured by the policy, or in respect of bodily injuries sustained by such an employee arising out and in the course of employment other than the liability arising under the WC Act in respect of death or bodily injury to any such person. That, my lord, clinches the issue. Once, my lord, he is the employee, then, my lord, the computation has to be in case of injury or death under the Compensation Act, Workmen's Compensation Act 1923, in respect of death of or bodily injury to any such employee. No judgment is required, my lord, except a clear reading of this provision of section 147.
What do you say in this 147?
Yeah,
Is what where the policy is required and
Yeah.
it covers whom?
My lord, provided,
Proviso reads.
provided, my lord, and after the Roman 2, my lord, provided that, Your Lordship got it, my lord?
Yes, policy shall not be required.
Shall not be required to cover the liability in respect of death arising out of and in the course of his employment of the employee of a person insured by the policy or in respect of bodily injury sustained by such employee arising out of and in the course of employment other than the liability arising under the Workmen's Compensation Act. That is the mandate of section 147. Therefore, my lord, my respectful submission, if for any reason, if the deceased were to be held, he was a employee under the insured as a cleaner, which they are not proved, then the computation has to be under the provisions of the Workmen's Compensation Act.
That is, if I hold that is an employee.
Yes. Suppose if your lordship holds that he is not an employee, then my lord, he has no right because he was being carried on the sand load.
All right.
Therefore, my lord, the risk is not covered.
All right. The appeal preferred by the claimant is on the ground of inadequate and meager compensation awarded by the Supreme. Brief facts of the case. It is the vehement contention of learned counsel representing the insurance company, Sri O. Mahesh. The tribunal has grossly erred in holding that the deceased was an employee of the insured and no positive or cogent and corroborative evidence is placed before the tribunal or before this court. He also further contends that it is admitted by the claimants that the deceased was traveling on the sand load in the lorry along with 3 others who are not covered irrespective of being a cleaner or passenger, as the person traveling in the tractor will have to necessarily sit in the cabin. And in the case of tractor, there has to be only the driver who will have to be driving the vehicle, and there is no other person who can be sitting along with the driver. It is also further contended by learned counsel that in case the petitioner the claimant claims that as claimed in the claim petition that he is an employee of the respondent number 1, then he would be covered under the provisions of the Workmen's Compensation Act and not as a third party if he is proved to be an employee of the insured, INSURE insured. He further contends that the deceased being a gratuitous passenger, as the respondent number 1 owner has not come before the court to say whether the deceased was his employee. There is no material placed by the claimant to show that the deceased was an employee of the owner respondent number 1. He cannot be treated as an employee of the respondent number 1. Therefore, it is his vehement contention that under section 147 of the Motor Vehicles Act, the proviso to section 1 reads as under extract proviso to section 1, clause 1. Under the above circumstances, the proviso to section 147(1) does not cover the person who's an employee under the Workmen's Compensation Act, and if at all he has to be granted compensation, same will have to be as per the Workmen's Compensation Act and not as a third party. Full stop. On the basis of these submissions, the learned counsel contends that the judgment and award passed by the tribunal is erroneous, arbitrary, and perverse, and the same requires to be set aside. Per contra, learned counsel representing the claimants was also prepared an appeal, vehemently contends that the tribunal has committed an error in not appreciating the material evidence placed on record, both oral and documentary, and has ignored the fact that the claimant was legally is entitled to compensation and has not awarded just and reasonable compensation, ignoring certain aspects of award of compensation with regard more specifically not awarding 40% of future prospects and also the conventional heads. It is also the contention of learned counsel for the claimant that even if the deceased was traveling over the sand load in the lorry as a gratuitous passenger, though the claimants themselves have claimed in the claim petition to be the deceased to be the cleaner of respondent number 1, owner of the lorry, he has not preferred the claim petition under the Workmen's Compensation Act. Therefore, having preferred to file a claim petition under the Motor Vehicles Act, the question of determining compensation under Workmen's Compensation Act does not arise. The liberties and the option is available to the claimant to approach before under either of the enactments, and when approached before the court under this particular enactment, the tribunal and the court will have to decide on the said enactment rather than adverting to the other enactment. He further contends that the tribunal has not awarded reasonable compensation, and even if he is a gratuitous passenger, the tribunal has rightly. What has the tribunal done? Huh? Will compensate liabilities fixed on the insurance company. Tribunal is right in fastening the liability on the insurance company to pay the amount. Whether any recovery is ordered, right in fastening the liability on the insurance company as the policy is in force. The same does not call for interference, and he seeks to allow his appeal by enhancing the compensation. We'll stop. Having heard learned counsel for the appellant learned counsel for the insurance company and the counsel for claimant, the point that arises for consideration is R1. The insurance company has made out a case for interference. Whether the claimants have made out a case for enhancement of compensation, what order? Full stop. It is not in dispute that the accident occurred on 3/2010. the involvement of the vehicle in question, the occurrence of accident, the injuries sustained by the deceased, succumbing to the death are all not in dispute. The fact of where are the exhibits in this? P1.
Exhibit P1 to P6.
The police records are furnished as exhibit P1 to P6, which are the copy of the FIR, the charge sheet, the postmortem, and the statement of PW2. The petitioner, the claimants have produced these documents to prove the occurrence of accident, the filing, the laying of charge sheet against the driver of the lorry, and the postmortem report to show the death having occurred due to the accident, which is not seriously disputed by the counsel for insurance company. However, what is disputed is that the insurance company is not liable to make good the compensation, and it would be the owner who would be responsible because of the non-coverage of insurance to the gratuitous passenger, and so also he being having claimed to be the cleaner. Compensation will have to be computed on the basis of what the Employees Compensation Act.
With your lordship's free, my lord, I would like to bring your lordship notice at this point, section 167 of the MV Act. The choice act. Option regarding claims for compensation in certain cases.
Yes.
Notwithstanding anything contained in the Workmen's Compensation Act 1923, where the death of or bodily injury to any person give rise to a claim for compensation under this act and also under the Workmen's Compensation Act, the person entitled to compensation may, without prejudice to the provisions of Chapter 10, claim such compensation under either of those acts but not under both.
Correct.
Yeah. My lord, here, my lord, what I would like to stress upon, my lord, that the forum does not, my lord, give a larger right to him. Once he has claimed as a cleaner, it has to be under the Workmen's Compensation.
All right, I've noted down your intentions. This court would not want to dwell into the occurrence of accident, involvement of vehicle, the death having occurred in the road traffic accident, as the same as not seriously questioned. Stop. The point for consideration would be whether what is the quantum of compensation and the liability to be fastened. Stop. In order to establish the question of award of compensation, quantum of compensation, the claimant has stated that he is aged 36 years. Though the postmortem report says 35 years, the tribunal has come to the conclusion that the deceased is aged 36 years. Hence, the same will have to be taken for calculation. The accident having occurred in the year on 3/4/2010, and there being no material proof with regard to income, the tribunal has assessed ₹200 per day as the income which amounts to rupees 6,000 per month. But whereas the notional income chart for the accidental year 2010 is rupees 5,500. Therefore, in view of the notional income chart prescribed by the Legal Services Authority, the income will have to be taken at 5,500 as against 6,000 adopted by the tribunal. It is seen that the tribunal has lost sight of the fact that the claimant was, the deceased was aged 36 years and has not awarded future prospects. Full stop. In view of deceased being less than 40 years, future prospects at 40% will have to be awarded. Therefore, 5,500 being taken as the income plus 40% would be 7,700. Full stop. The deceased has left behind 3 dependents. In view of the same, the deduction towards personal and living expenses will be 1/3. 7,700 to 1/3. So 5134 would be 5134. Full stop. The deceased being aged 36 years, the appropriate multiplier would be 15. Same is rightly adopted by the tribunal and it's retained. Therefore, loss of income towards the loss of dependency in the present case would be 5,134 into 12 into 15. $9,24,120 as against 7,20,000 awarded by the tribunal. It is also seen that the tribunal has not awarded the consortium as held by the Honorable Apex Court in the case of Pranay Sethi, Magma, and Satinder Kaur. The dependents, claimant dependents would be entitled to 40,000 per head. There being 3 dependents, 1,20,000, 40,000 into 3, 1,20,000 would be the consortium. Full stop. The tribunal is awarded 30,000 towards transportation of body funeral expenses, which is retained. Apart from this, 10% of the amount towards conventional debt will have to be awarded in view of the judgment of the Apex Court in the case of Pranay Sethi. 1,50,000 agutalla, 15,000 is to be added. Full stop. Now coming to the question of liability, the tribunal has fastened the liability exclusively on the insurance company and directed the insurance company to deposit the amount within 3 months. On perusal of the entire impugned judgment and on the submissions of learned counsel for both the parties, Mr. Mahesh, you wanted to read that Cholati Bharatamma's case. Which para you wanted to read?
Well, they have extracted section 147 in the beginning itself, my lord.
Okay. Only for that purpose you wanted to read?
Yes, my lord, and also said, my lord, the insurance company appeal was allowed. And the order was set aside.
And liability was fastened on the owner?
No, my lord, there is no, only appeal of the company was allowed. That invariably, my lord, leads to that the owner is held liable.
He relied on one more. Very good. On the question of liability, the counsel for the insurance company arguments is appealing as the deceased was traveling in the truck loaded with sand, which is impermissible. And the liability is limited to the insurance company with the persons who are insured. And in the case of tractor, apart from the driver, there is no other person who is permitted to travel. Under these circumstances, I am in agreement with the learned counsel for the insurance company that the tribunal has committed an error in fastening the liability against the insurance company to make good the payment and exonerating and absolving the liability of the owner. However, in view of the judgment of the Honorable Apex Court in the case of Shivraj versus Rajendra and another reported in 2018, Supreme within bracket SC 863, which has considered this very aspect in detail after relying on the judgment of Swaran Singh's case, Mangala Ram's case, Asha Rani, Manura Khatun has held that the deceased having traveled as a gratuitous passenger, the claimants would be entitled to compensation, which would have to be paid by the insurance company, and would the insurance company be at liberty to recover the same from the respondent number 1, owner of the offending vehicle. Under these circumstances, the claimants in the present case would also be entitled to the very same ratio laid down by the Honorable Apex Court. Hence, I pass the following order. In view of the discussions made above, the claimants would be entitled to total compensation of 10 lakh, 89,000, so and so, as against 7 lakh 70,000 awarded by the tribunal. The compensation, the judgment and award of the tribunal is modified, and total compensation of 10 lakhs so and so shall be the liability is fastened on the respondent number 1, owner of the offending vehicle. However, in view of the policy, in view of the insurance company having the policy in force, would be liable to make good the compensation, but would be at liberty to recover the same from the respondent number 1, owner of the offending vehicle. The entire compensation shall be paid within a period of 6 weeks from the date of receipt of copy of this order. At 6% per annum. The enhanced compensation also shall carry the interest at 6% per annum. The claimants will be entitled to apportionment of the compensation as per the judgment and award of the tribunal. So also the deposit ordered by the tribunal. So also back to the deposit, fixed deposit and other deposits ordered by the tribunal in the nationalized bank of the choice of the claimants. Or in minors either.
2 are minus.
Major antar
Like your major again.
All right, then. So now they are having their own account. So then you have to. To make order, but in view of the fact that as on date, the respondents number 2, the claimants number 2 and 3 have attained a majority, the apportioned compensation shall be paid to them directly rather than the claimant number 1, who was then the natural guardian of the claimants number 2 and 3. On deposit of the apportioned compensation amount, what is the amount that will come? What is the total amount, madam? 10 lakh, 89,000, 120. Make it as 10 lakh, rounded off to 10 lakh 90,000. They are children, 2 and 3.
They are children, daughter and son.
So what should be the apportionment, Mr. Mahesh, generally? 70% or?
20, 25, 25, 50.
25, 25, 50. Okay. All right. The apportionment of the compensation is also made by this court. %50 mother ಬರುತ್ತೆ. Right? These are now majors, the Kumari Geeta and Master Nagesh. He must have married and gone.
They have to open a
20,
bank
60.
account to which it can be credited.
All right. 60 madana, mother 60 koda.
What I am saying is, the account has to be opened in the name of one of the second and third respondent.
Correct. But they will do it. The apportionment of compensation would be 60% to the claimant number 1, wife of deceased, and 20% each to the children of deceased, namely claimant number 2 and 3. In case the claimants do not have an existing bank account, the same shall be opened in their respective new names, and after providing the account details, the compensation amount shall be released directly in favor of the claimants 2 and 3, 1, 2 and 3. Right? The trial court records shall be transmitted to the jurisdictional tribunal forthwith.
That amount in deposit.
Amount in deposit, along with the amount in deposit made before this court by the appellant, by the insurance company.
Lord, yesterday due to video disturbance, Lord, I could not appear, Lord.
All right.
Few cases which was posted yesterday.
ನೀವು ಬಂದು ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನಮಗೆ ಇನ್ನು ಇಟ್ಸ್ ಅ ಪ್ಲೆಜರ್ ಟು ಹಿಯರ್ ಮಿಸ್ಟರ್ ಮಹೇಶ್ ಇನ್ ಓಪನ್ ಕೋರ್ಟ್.
ನೆನ್ನೆ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಬರ್ಲಿಲ್ಲ, ನಾನು ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಮಾಡಿದೆ, ಅದೇನೋ ರಿಪೇರಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
We are facing still some glitches on this technology, but we'll have to adjust. But anyway, who are appearing regularly before me, matters will not be damaged. You can take it. Standard. Raju, Ravi Shankar, ಏನಿದು ಕ್ಲೈಮೆಂಟ್ both insurance and claimants ಮಾಡಿ structured formula. So claimant is fell down, skid and fell down. He's the rider. So what has happened? Death case. He could not have filed 166. That's why he has filed 163A. Right. Good. Which is the judgment says 1 lakh? Yes, what is your argument? Our argument ನಿಮ್ಗೆ ಏನು ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. 163A. You are the rider. ಅದೇ ರೈಡರ್ ಬಾರೋ ಮಾಡ್ಕೊಂಡಿರೋದು. ಫ್ರೆಂಡ್ ವೆಹಿಕಲ್ ಬಾರೋ ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ. He has not stolen it. Or whether you borrow, steal or whatever. You beg, borrow, steal. Just step into the shoes of the owner. No, but it. Kodre, which is the judgment you are relying? Tandilwa. Putting. ನೀವು ಹೈಕೋರ್ಟ್ ಕೊಡ್ತೀರಾ? ಹೈಕೋರ್ಟ್ ಕೊಡ್ತೀರಾ? ಕೊಡಿ. All right, you read the Sunita's case. Read it. Para? Which para?
Okay.
Come to the relevant portion. All right, ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ನೀವು ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ನಿಮ್ದು ಯಾವಾಗ ಇವತ್ತೇನಕ್ಕೆ ಬಂದ್ರಿ? Should be prepared. 2014 ಕೇಸ್ ಇದೆ, ನೀವು ಇನ್ನೂ ಇವತ್ತು ಬಂದು ಸುಮ್ಮನೆ ನಾಳೆ ತರ್ತೀನಿ ಅಂದ್ರೆ All right, you also read the relevant portion. Don't read head notes like. ಅದು ಗೊತ್ತಿದೆಯಲ್ಲ 163 structured formula, no fault theory, no need of proving negligence. You need not tell that it's very established. That the law itself is says so. You have to come to the very specifics that he gets into the shoes. The compensation has to be 1 lakh and not the structured form. That's all you have to say. He's trying to distinguish this, bring out that. Learned counsel for the claimant seeks time. Release this matter on. Wait, ಕೊಡಿ. ಯಾವಾಗ ಮಾಡ್ತಾರ್ರಿ? 6ನೇ ತಾರೀಕು. 7, 8, 9. 9th. Yes, Mr. Girish and Madam. You are not ready today. You are tired. Right, so what is the serial number? No, it is already 2021 petition. You have come before the court in 2021. This court does not inclined to detain you further. You have to be given the relief either yes or no. Yes, this court is not inclined in dragging on, prolonging the matter. All right, you take time, no problem. When you want it on that day, you have to argue the main matter along with your application. But that's your choice. That's your choice. You are welcome to take an advocate for assisting you. You can do that. So on that day, I will hear the main matter as well as your application for direction together. You also come prepared. Whatever judgments with regard to maintainability of the petition or application and other things. Whichever date you choose from the calendar, here. ಇಲ್ಲಿದೆಯಾ ಕೆಳಗೆ? I just posted few matters. 21st October. We can have it on 21st. 21st, don't take time and you be here on that day. Don't make her detain in the court. Release this matter on 21st at request of the 13% Srimati Anura. Your Srimati or Miss? All right, then Srimati Anuradha Kotha. Counsel for the University, Girish Kumar is also present. Released on 21st. Yes. Yeah. ನೀವೇ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಕ್ಲೈಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಕಲ್ಯಾಣ್ is not here. There is no representation on behalf of the appellant. Learned counsel H.S. Ringlaj is present on behalf of the insurance company R2. Release this matter next week. In the 166 petition is allowed or dismissed? Enhancement bill. So owner has to pay. So now he is trying to implicate you. ನೀವು ಇಂಪ್ಲಿಕೇಟ್ ಮಾಡಿದ್ರೆ ಪೇ ಅಂಡ್ ರಿಕವರ್ ಆದ್ರೆ ನೀವು ಕೊಡ್ತೀರಾ ಅಂತ ಅವ್ರಿಗೆ. ನೀವೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಸೂರ್ಯನಾರಾಯಣ ರಾವ್ ಅಂತಿದೆ. You can file wakalat and get your name. So argument by whom? Without wakalat. I will permit if anything goes wrong and the insurance company is going to file case, it will be faced by Ravi Shankar. Complaint. Accident on 28/2/2005. So after 2 years, I think. Complaint. Case filed on. Case of injury, is it? So 2005 accident, 2007 complaint, and 2009 is the case filed, claim. No application was filed for delay. So the claim petition is allowed. What is the compensation? All right, let him come. We'll have it some other day. Learned counsel for the appellant is present. No representation on behalf of respondent. We list this matter next week. Week after next. Week after next. Sashidhar. Policy is there. That is your opponent, Sridhar. Sridhar. Yaru? Sridhar or Shiv Kumar Swami? So your claimant seeking enhancement fixed on the owner. Ibru bekalla ಮತ್ತೆ. So case Sridhar appears for insurance company. DL Shivkumar Swami is so nobody has filed wakalat. Okay. Learned counsel for the appellant claimant is present. There is no representation on behalf of respondents. Relist this matter week after next. Death case next week.
Sheshagiri Rao.
CH Rao. There's no representation on behalf of petitioner. Learned CGP is present before the court. Relist next week. Genealogical tree. Copy of election card. Anything? Filed by whom? Grantee or purchaser? Matraidia. Let's take one copy from him. Learned there's no representation on behalf of writ petitioner. Learned CGP along with the learned counsel for R1 are present. Purchaser. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಗೌರ್ಮೆಂಟ್ಗೆ. When was the grant made? 1952. Govindappa.
Grant is made on 1950. 18 to 1952. First sale is made on 69. Second sale is made on 70.
Second sale is
70.
to the same person.
Same person. Yeah, no, same. Maybe same. We can sort out.
The entire 2 acres is sold.
The restoration of
Govindappa. Sold to go. You are the LRs of Govindappa. ಎಲ್ಲಿದೆ ನಿಮ್ ಗೋವಿಂದಪ್ಪ ಅಂದ್ರೆ ಏನು ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್? Then what happened?
30 years. Important.
Who is in possession? ಯಾವಾಗಿಂದ? What are you doing there? ನೀವು ಗ್ರಾಂಟಿ ಅಲ್ಲ. Documents where? Senior ಬರ್ತಾರ. Whether he attends or you attend, facts will not change. 30 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ ಮಾರಾಟ ಮಾಡಿ 69 ಅಲ್ಲಿ 73 ಅಲ್ಲಿ how you can now claim? You want to argue today or some other day? Madi. This order. Filings. The order of DC. Ah. Hello. ಎಲ್ಲಿದೆ? ಹಾ. Kenchappa ಯಾರಿದು? One Kenchappa. Appellant's uncle purchased 1 acre of land from one Kenchappa. Kenchappa himself. ಅವನ ಹೆಸರು ಕೆಂಚಪ್ಪನ? Original purchaser ಯಾರು? ಗೋವಿಂದಪ್ಪ. All right, you do one thing. You give a list of this detailed synopsis bar chart of the genealogical. You have produced some genealogy tree. Look at it. Yes, you do one thing, you provide a translated copy of this genealogy tree by hand. Give it translated into English. He claims.
The question is that whether the before casting.
Kencham. You are children of Kencham.
The main question is here.
That we'll see. Give this details. Change this.
Even we find that this is not the successors of Oriental blood.
You are not in possession. Huh? Granted land is survey number? 4/11 or 41/11? 4/11. Right, you are in possession of your land. He is in possession of your land.
The other problem. Also having a property, 41.
Give that. Translate that into English and give that. Author copy the government. You are having copy. Counsel for the petitioner to furnish one set of petition copy to the learned HCGP. At least to the petitioner to furnish translated copy of the genealogy tree. Sale deed ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ ಅದರಲ್ಲಿ? Tim, do whatever. All right, released week after next. All right, hold on. 445 will get.
Number 71, exam 72. In Naranappa.
Your Shivshankar. Naranappa illi. Purchaser's petition. You are in possession. You are continuing. You are continuing in possession. Learned counsel for the petitioner is present. No representation on behalf of respondents 4, 3, 4, and 5. Learned HCGP is present. You have got copy? Relist week after next. Next week? Next week. Interim order is absolute or has to be extended? Interim order, if any, is extended till next week. You're ready? You'll be able to finish in 15 minutes. Have it some other day then. Relist this matter on 23rd March. Hmm. Hmm. Huh? Your purchaser. When did you purchase? Grant in? When is the sale? From Neelappa. So Neelappa was the original grantee. Hirappa. So he sold to Neelappa. Hmm. All right. You purchase from Neelappa. Second sale. ಯಾವಾಗ? So that was dismissed. That was One acre, 15 guntas. So what's the amount of delay from 1975 to 2000? '28 Act came into force in 1979. '99, 2009, 31 years. 2010 years filed. 31 years, but the 40 years again. So that's your main ground. Indeed. Oh. With a section 35. What is 3.5? Of PTCL Act. No, 3.5 ಏನೋ ಅಂತ ಇದ್ದಾರೆ ನೋಡೋಣ. What is 3.5? The 3.5 ನನಗೂ ಗೊತ್ತು. ಡೆಫಿನಿಷನ್ ಇದು ಇವಾಗ ಹೊಸ 3.5 ಏನ್ರಿ? ದ ಡೆಫಿನಿಷನ್ಸ್ ಅಲ್ವೇನ್ರಿ 3? Even if there is anything 3.5, what were you doing for 31 years? Okay. The 3.5 itkondru, nothing prevented you to go before the court on time. That is what the apex court has said, and this court also, I have also passed an order. Huh? 1999. So that is also 99, 2009, 11 years. But the challenge that you have made before the AC is 31 years. Not surviving. What is 3.5? 3.5 or 3 alladu, something else. 3 is a definition.
prepared some evidence on the parties.
ಅದು ಎವಿಡೆನ್ಸ್ ಆಫ್ ಪಾರ್ಟಿಯಲ್ಲಿ ಮಾಡಿರ್ತಾರಲ್ಲ AC ಮುಂದೆ. Inquiry will be committed. So moto he can do, even on application he can do. So inquiry, notice, then order, then challenge in DC. That also I think is fast.
So it is in ground in the repetition.
Dismiss ಮಾಡ್ಬೇಕಷ್ಟೇ. Dismiss defense. Dismiss the defense taken and allow the petitioner. You're filing now in a memo. Reporting the death, then you have to carry out the amendment. Counsel for the petitioner files a memo reporting the death of first petitioner, namely Baswantappa. Indriya Baswantappa Chindera Kerurona, who died on 4/8/2019. It is further stated that the petitioner number 2 is the only legal representative of petitioner number 1. Here is a copy of the death certificate. Annexed ಅಂತ ಹಾಕ್ತಾರೆ, ಬರೀ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. What happened to his wife Manjamma? ಅದೆಲ್ಲ ಹೇಳ್ಬೇಕಲ್ರಿ. You have to say in this memo that his wife Manjamma has predeceased him. Say so. And the wife of first petitioner has predeceased him. Hence the legal representative of petitioner number 1 is none other than petitioner number 2 and none else. In view of the submission and memo just placed on record, petitioner is permitted to carry out the amendment and file the amended petition copy by serving a copy of the same to the other side. I will take it as heard. Okay, you carry out the corrections in this. That his wife Manjamma has predeceased him on that. But not as much. This must be in the rules. Be the rules. Read it. ಫಾರ್ಮಲ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದಾರಲ್ಲ. ಎನ್ಕ್ವೈರಿ ಮಾಡದೆ ಆರ್ಡರ್ ಎಲ್ರಿ ಮಾಡ್ತಾರೆ ಅವರು. ಏನೇ ಮಾಡ್ಲಿ ಅದರಲ್ಲಿ ಒಳಗೆ Sure. Fourth line. What is that? Read that Tahsildar Shorabana. Cover it. So report is obtained from Tahsil. Petition is allowed. A writ of certiorari is passed, quashing the order dated 30th August 2016 of the Deputy Commissioner, Shimoga District, Shimoga, as being. And what about the AC order? So consequently, that also has to be quashed. So your assistant commissioner rejected. It's a scheduled caste. So now Valmiki's are scheduled caste. Okay. Cannot dismiss the application filed by 4 and 5. The second prayer cannot be allowed. How can you dismiss that application? He can file that is rejected. CST PTCL number another. No, where have you stated in your prayer? What is that number? SCST? Appeal 1, SCST appeal number 1 of PTCL Act. PTCL, Stay. Annexure M alvenri. We are seeking quashing of annexure M. relying on the judgment of Nikanti Rama Lakshmi. And that, what is that? Ajay Vivek Ahuja. Ahuja, Hinduja, Vivek Hinduja. Detailed order will follow. Sama? Give a date. Which is this one, 75, is it? Sangamesh Patil. 77 realist next week. At request of counsel for respondent number 4. 76. 26. Respondent 4. Who is RC Nagaraj? There's no representation on behalf of petitioner. Learned counsel for respondent 4 is present. Any urgency? New York. Empty. So purchasers petition. Who's in possession? All right. Released week after next. In 78, 79, 80.
81, kindly a date may be given, Lordship.
What is this matter, madam?
Lordship, I have challenged the valuation, Lordship.
So if she passes here, then
Lordship, kindly.
yes, Madam Suman.
Lordship, kindly direct the respondent to produce the details of the marks. In fact, that has been produced by the respondent in the earlier round of litigation, Lordship. I'll be able to demonstrate where the mischief has been played by the respondent, Lordship. That is very much necessary. In the statement of objection, the respondent has not filed the details of the marks. That is very much needed. My case is purely on facts.
All right. We'll have it next week. You have
Please,
placed
Lordship.
your objections. You have served copy. You have received the statement of objections.
Please, Lordship, but this particular detail of marks is not available in the statement of objections, Lordship.
All right, we'll see.
She has produced it in the earlier round, Lordship. Same thing needs to be filed.
All right. Learned counsel for the petitioner and learned counsel for the respondent number 1. Where is Mr. KT? Are present before the court. Read this matter. We'll have it week after next. By then, the results will be out. Read this week after next, madam.
Lordship, after around 10th, Lordship, if it is convenient to Lordship.
All right, released on 10th.
Obliged, Lordship.
Thirteenth. Madam Sumana, 13th.
Please, Lordship.
Monday, Barley. Nagarajappa. Hey. Emergency, 84 urgency. Last matter. Emergency. Now, what is the urgency now? Right, we'd have it tomorrow. This is now coming for final hearing, is it? B group. How did it go to B group? Rule is issued. All right, rule is tomorrow. Who's on the other side? Nagarale. Which course is this? Speed and everything.
Madam, serial number 65 and I. Court officer, serial number 65.